The regular call Civil Service Board agenda meeting for February 28, 2024, and the time is 9:04 a.m. Call meeting to order. First item, adopt the agenda for this meeting.
Move approval, Madam Chair.
Second.
So moved and approved. Item 3, consider approval for Civil Service Board meeting minutes held on January 24, 2024.
Move approval.
Second.
Approved. Consider.
You need to vote.
That's different. This is like-
Item 3, sorry. Item number 3,
Start with 2.
item 2, adopt agenda for this meeting.
Need to call for a vote.
Call for the vote.
Vote
All in favor?
aye.
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 So moved and approved unanimously.
Number 3.
Item 3, consider approval for Civil Service Board meeting minutes held on January 24, 2024.
Move approval.
Second. All in favor?
All in favor?
Aye.
So moved and approved unanimously. Consider approval for Civil Service Board executive session minutes regarding human resource purposes for administrative governance that was held on January 24th, 2024.
Move approval, Madam Chair.
Second. All in favor?
All in favor?
Aye.
Aye. So moved and approved unanimously. Item 5, consider request from Code Enforcement Officer Neela Cox Aldridge, Corrections Prison, to receive annual leave donation. Civil Service Board was polled and approved on February the 6th, 2024. That was my birthday, by the way, y'all.
Happy birthday.
By myself, Watkins, Smith, Jackson, Phillips Hall, and Lancaster.
Move approval.
Second.
All in favor?
Aye.
Aye.
So moved and approved unanimously. Item 6, consider request for Police Chief Kevin Roberts, to use sick leave in lieu of annual leave for Master Police Officer Swan, thank you. Police Department from March 12th, 2024 through April 30th, 2024. Mr. Green?
Madam Chair and Board, my name is Ken Green. I'm Staff Attorney for Clayton County Police Department. Chief Roberts is asking you to approve Officer Swan's request to take sick leave during his FMLA period. He's going to be in the country of Laos. His father's extremely ill. And HR has indeed granted him FMLA for that period, and he's requesting to be allowed to use the sick leave for that time. Typically speaking, as you know, in our rules, the person would have to live, the family member would have to live with you in order to qualify. So that's why it's come to the board to make this request.
Any discussion?
I just,
Move approval.
well, I just,
Let's get it then.
Good morning, board, and good morning, everyone here. Yes, it does. Dr. Jackson, it fits within the guidelines.
But I said I move approval.
second.
All in favor?
Aye.
Aye. So moved and approved. Unanimously. Item 7, consider request from Police Chief Kevin Roberts for leave without pay for police recruit Ken Benton, Police Department, from March 13th, 2024 through March 16th, 2024.
Madam Chair and board members, this is a relatively new police officer. He's not completed his academy, still in recruit status. His wife is going in for surgery and she's going to be incapacitated for a few days. So he's asking permission to take off to care for the children. The chief of police asks you to grant his request to take leave without pay for that period of time.
Move approval.
Second.
All in favor?
Aye.
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 So moved and approved. We have a couple board members are not physically present, but Mr. Smith is on Zoom and he's attending this meeting. So I just want to bring that to everyone's attention. Calendar call. Catherine Thrift, Police Department, termination appeal filed on May 18th, 2020 regarding my termination.
Madam Chair, members of the board, I'm Don English. I represent the appellant. She will not be here today. And she does understand that that will likely result in a dismissal of her appeal.
Whereupon we move to dismiss the appeal from warrant of prosecution.
Madam Chair, I move that we approve the county's dismissal request.
I second that.
All in favor?
Aye.
Aye. Case is dismissed. 8B, Shalonda Riley, Magistrate Court termination appeal on November 15th, 2023 regarding my termination on November the 7th, 2023.
Good morning,
Good
Civil
morning.
Service Board. I am Shalonda Riley and I'm president. I
Okay.
present my case.
Have a seat for just a minute. Thank you. Item C of 8, Kyle Sherritt, Fire Department, grievance filed on November the 15th, 2023 regarding Clayton County Fire Emergency System has changed the personal holiday section of resolution number 2023-134 and their latest update to Clayton County Fire Emergency System Police 1046.6.
Yes, ma'am.
Mr. Sherritt,
Yes, ma'am.
you ready?
Yes, ma'am.
I'm sorry.
Yes, and we are president, we are ready.
All right, thank you.
Madam Chair, I'd like to make a motion that we move. Mr. Sherritt's grievance to hear that first, since I believe he'll only have 30 minutes to make his presentation.
Okay.
And then all the fire department people can go back to work, and then we can move forward with the other case.
Yeah, protect our houses.
All right, set me for a minute. Board will take a short break for 5 minutes.
We need a motion. Make a motion, we take a short break.
Second.
All in favor?
Aye.
Aye. We'll be on break until 9:17.
I'll sit here beside you on this side, that would be good.
Okay.
Thank you. How are you? Back to order. 9:18 a.m., February 28th. And the item on the agenda is the grievance of Mr. Kyle Sherritt by department. Each party will have 30-minute time limit on a grievance. The timekeeper will be Ms. Lancaster. If you have any questions about where you are in your time, you can ask Ms. Lancaster. She'll give you the correct time. This time includes opening statements, examination, cross-exam, closing argument. The board will ask any questions. The parties will present their case to the board. Are you ready to proceed?
Yes, ma'am, we are ready. If it's a grievance,
It goes first.
yes, ma'am.
Yes, ma'am. Is the IT up and running? I'm getting texts that people are having a hard time watching.
IT, please start the recording.
Yeah, it's
It says
recording.
recording.
Outstanding.
Yeah.
Are we ready?
Yes.
Thank you. Greetings, Civil Service Board. I'm here today to request your help. Yes, ma'am.
I have a learning curve every month on this thing.
Sure.
Um. Bessie, help. Sorry.
Oh, you're fine.
Thank you. Didn't get that stuff. It counts down. I'm really technically challenged. Okay, go ahead. Sorry.
Yes, ma'am. Today I'm here to request your help in stopping my fire department from the long-term trend of elimination or limitation of firefighter benefits. For instance, the longevity check was a monetary bonus issued at the end of the year for employees who were loyal members of the department for 7 years or more. Now, without that loyalty benefit, the current average experience of an online firefighter is less than 5 years. Out of class pay was something that an employee received financial compensation for being forced to fulfill their roles as a supervisor when their supervisors were absent. Now the employees are forced to accept the responsibility without compensation, and in some cases, for years. Then there's compensation time. This is when an employee would accrue time off at a rate of time and a half in lieu of financial compensation when working for the department on their day off. Now they receive no form of compensation for working the additional hours. Outside training opportunities. And employees were considered at work when they were at these classes. Now, if they get the approval for a class, a firefighter has to request one or more fellow firefighters to work 48 hours straight to cover their shift while they're away at this class. And we call these things time trades. In order for the department to allow the firefighter to attend the class, and this class would help the department and better the department. Now they have to actually use time trades. Now a time trade also has limitations. When employees need time off but couldn't get approval for things like my child's graduation, weddings, funerals, a child's sporting event, and also now this includes training classes. Now firefighters are limited to about 120 hours to work for fellow firefighters, and they can work 120 hours for a fellow firefighter. This limits a firefighter's training opportunities. These are just some of the firefighter benefits that have been stripped away over the years. The current administration is now limiting one more, the personal holiday. On July 20th, 2023, the county commissioners signed the resolution 2023-134. The fire department adopted the resolution, but clarified what reasonable advance notice was. They've now written down 30 days advance notice. This limitation, which I'll show today, inhibits firefighters more from utilizing their county benefits than the original statement for the county resolution. Please help me prevent the current administration from taking more of a benefit this way. Thank you.
Before I proceed, I just want to clarify something for the record. I was going to make an objection, and I'm based on the last statement that Mr. Sherritt made. I don't know if I need to do that, but I need to note for the record, he has identified probably half a dozen benefits that he claims have been eliminated, and that is not the issue before you today. The sole issue before you today that was the subject of this grievance is the personal holiday as it appears in departmental policy 1046 that was approved in resolution 2023-134. And I want to be very clear that for the record, that is the sole issue before you today. And if there's going to be any attempt to make any argument about anything else, then I object, because that is not what was presented or notified for this hearing.
I have a question for our legal person. This resolution was approved by the Board of Commissioners, correct?
Yes, sir.
And it had to be adopted by the fire department, correct?
Well, they did not have to adopt a separate policy, no, sir.
Thank
That's what I have. Okay, so as long as that's. And I hope that my opening will help clarify for you, Dr. Jackson. The personal holiday is a benefit that is conferred by the Board of Commissioners on an annual basis. It is not a standing holiday. It is not a standing benefit. It is not an entitlement. It is something that the Board of Commissioners, of the goodness of their heart, to provide additional paid time off for employees that they consider on an annual basis. Last July, in Resolution 2023, they did approve a personal holiday. And specifically, what the Board of Commissioners said was that reasonable advance notice of the requested day should be given to allow the elected official or department director the opportunity to process the request. And it goes on to recognize that there may be a limitation to the number of employees that are allowed to take off on any given day. And that priority for granting the personal holiday shall be based upon the date the request is received. And seniority is the second determinative criteria. So there are limitations actually in the resolution approved by the Board of Commissioners. The fire department adopted a policy recognizing the personal holiday and establishing what constitutes reasonable advance notice for the fire department, precisely as the Board of Commissioners allowed in the resolution, because different departments have different operational needs, and what constitutes a reasonable notice for one department may or may not be reasonable notice for another department. Reasonable notice in this case was established on the same basis as advance notice for other kinds of leave, the annual leave for the fire department, because the policy enacted by the fire department is almost verbatim of the resolution, other than specifically establishing the criteria for advance notice as provided by the resolution. We ask you to deny this group.
Mr. Chair.
Ma'am, was she done?
Yeah.
Okay, you want me to call my first witness?
Yes.
If you wouldn't mind, could I please see Interim Chief Sweat?
Mr. Zimmerman, can you swear the witnesses in?
Yeah.
All witnesses who will be testifying in this case, please stand and raise your right hand.
You swear from the information testimony you'd like to give before this court be the truth, whole truth,
You are going to testify.
so help you God.
No, sir.
I do.
For the record, we have sworn in Chief Tim Sweat, Chief of Staff Laura Richardson, and Captain Lawrence Adams.
Thank you, ma'am. Chief Sweat. I consider myself more of a problem solver. So when looking at this aspect of when I brought the grievance to order, I was wondering if I could ask you a question, okay? If our current vacation calendar was moved 4 months forward and would sync with the fiscal year calendar, wouldn't every firefighter be able to request their personal holiday, which would be a reasonable advance notice for that year?
Could that be possible?
Yes, sir.
Yes. However, once again, reasonable advance notice, as the fire department policy has stated and has been adopted, will still remain with 30 days of advance notice.
So even though we do our requests 1 year out in advance for our vacation calendar is set out for 1 year. And I would consider, a full year out reasonable advance notice. You would feel more comfortable limiting it to 30 days advance notice instead of placing it alongside with, say, our vacation requests, which would assure a firefighter's personal holiday through that given year, instead of fighting for whatever scraps are open and also based on attrition. Is that true?
Yes.
Okay,
Given that there are other things that have to be settled and placed on the calendar first, prior to the consideration of the question.
Okay. With the overtime being $4,532,669.54 in 2023, have your bosses requested that you find a way to minimize overtime?
First, I cannot vouch for the number you just stated, I don't have that information in front of me.
Understood.
Secondly, no, I'm not been given an order to do anything to address overtime, other than the order that I carried out.
Thanks, sir. If every firefighter's personal request for time off were denied, would that reduce some overtime costs by not allowing them to take the time off?
Say that more.
If every firefighter's personal holiday were denied for, say, a calendar year, would that reduce some of the overtime costs? By in other words, not having a firefighter at work would mean the possibility of having overtime. So if we didn't allow them to take the time off, it would save some overtime cost.
Well, given that the Board of Commissioners votes and approve the holiday, personal holiday, I cannot deny them that holiday. So I cannot directly answer your question.
Understood. According to the resolution 2023-134, the personal holiday must be observed between July 1st, 2023 and June 30th, 2024, the county fiscal year. The holiday will be forfeited for the year if they don't utilize that benefit. Is that your understanding?
Yes.
C12 has listed our calendar out. Were you aware, if you take a look at that calendar, that 28% of B shift billeted positions were able to utilize their holiday in 2023?
You asked me if I'm aware of that.
Yes, sir.
I do not get this granular with the shift schedules. I have leadership in place that manages this for the organization.
Would be any reason to think that what I'm saying is incorrect?
Without looking at the actual exhibit and running the numbers. I can't.
Understood. Okay. Are you aware that I'm currently the most senior man on B shift? And as my understanding is that if I request every shift off 30 days out while working, would I receive preference over a personal holiday request?
Given that you are the tenured senior personnel on this shift, there's different rules and regulations when we look at them. So if you're speaking solely to your personal day, once again, the resolution in our policy states that seniority comes second based off the initial request. So an individual that did not have seniority over you requested a personal holiday before you, and that individual will get it over.
If I requested every day for the calendar year, so therefore I have requested it first, because time off is limited. Any request after that, less of seniority, even if it was a personal holiday, would be denied over my acceptance. Would that be correct?
Well, when you're saying if I request every day off, or are you saying you want to request every single day for the entire calendar year off?
I apologize. I'm more of a storyteller. Lieutenant White was my lieutenant when I first started. He wanted some time off, couldn't get it. So he made it a mission to request 30 days out every single day so he could finally get a day off. Now, by doing that, he would get a regular day off here and there, but it would also limit the lesser senior people to have time off.
I'm gonna object. He's testifying. He's not
So
asking a question.
could I do the same? You need to let me finish this question, man.
Sustain.
Could you request something? Sure. As well as any other member of the organization. As long as the request is 30 days in advance.
Yes, sir. On March 19th, 2023, you were able to answer a tax portal question about personal holidays. In the answering to my question, your statement was, you stated that the supervisors are automatically assigning your first A-day request as your personal holiday. While I cannot confirm or deny your statement, we will look into it and take the necessary corrective measures if needed. Would it shock you to know that according to the 2023 calendar, B-shift calendar, vacation calendar, nearly 90% of personal holidays were assigned to the firefighter and not requested by the firefighter?
You're asking if that would shock me? No.
In the resolution, isn't a firefighter supposed to request the personal holiday, not be assigned by their administration?
Yes.
So 90% of the personal holidays were not in line with the resolution then?
Well, you're stating something that occurred in the past to where I enforced a policy to correct it in the future. And the policy in question is what you're reading today. I can't speak to the past.
Yes, sir. Now, when you answer the PAC Portal question about looking into it, 80% of the requests still remained as assigned. You said you fixed the problem after, was that after the PAC Portal or it took
Object, I just
time
said that-
after?
He's assuming facts, not in evidence.
It's on A4 and C12 of the calendar.
If he wants to put a document into evidence to establish the foundation for that question, that's one thing, but his statement amounts to testimony as the predicate for that question. I object to facts, not in evidence.
Sustained.
In A4 is the answer to Chief Sweat's question to the PAC Portal.
So what now?
A4 in the evidence for the appellant, A-4, is Chief.
My hearing aids are malfunctioning. If you want me to hear, you gotta be more concise and precise in what you say. Otherwise, I don't know what you say. I'm not a lip reader. Understand?
Yes, sir.
All right.
So in A4, that's the
okay.
appellant for,
A4.
yes, sir. Chief Sweat's answer to the PAC Portal question is in there about corrective measures. And C12 is the calendar for the year. And if you look at both, you'll see that the date in which I asked the question, and also when it was answered to be corrected.
Now, give us time to get you.
Oh, sorry, sir.
You know,
I know, I've reviewed these documents a lot
hey,
faster.
hey.
What's
If
your
you
question?
want us to do it, then present it. You've been here before. You know how this works.
I'm slowly getting it.
You know how this works. So let's get it right, okay?
Sure.
Your question, Mr. Chair.
I no longer do. Thank you, Chief Sweat, for your time.
A4. And what's the other one? Now, what did you want us to look at in A4?
Sir, I'm moving on.
He no longer has a question.
Thank you, Mr.
My turn. Chief Sweat, prior to the adoption of your policy, 1046, how were personal holidays provided to employees of the fire department?
They were oftentimes given to the employee at the start of the fiscal year, which is July 1. Once the Board of Commissioners approved a personal holiday for that fiscal year, oftentimes the first annual leave or vacation day that was on the calendar already was then converted as a personal holiday to ensure that each employee did not lose that.
And that practice was questioned by Sergeant Sherritt, is that right?
Yes, sir.
And you ended up implementing policy 1046, is that right?
Yes, sir.
Direct your attention to exhibit C5, please. Is that the entirety of policy 1046 that you implemented? Does it address personal holidays? Does it address other kinds of leave requests?
Yes, ma'am.
In section 1046.6 addressing personal holidays, is this the first policy the fire department has had that speaks specifically to personal holidays?
The best I can determine, yes.
So the previous policy didn't have a corresponding section addressing personal holidays, is that right?
That is
What is considered reasonable advance notice for an employee who wants to request a personal holiday?
30 days in advance.
What is the reasonable advance notice required for an employee to request other kinds of leave, such as annual leave?
30 days in advance.
If an employee requested every single shift they were scheduled to work for an entire month or an entire year, would those days be granted?
Don't have, civil service doesn't allow.
Direct your attention to exhibit C4, please. Is this the resolution that was adopted by the Board of Commissioners establishing the personal holiday for the current fiscal year?
Yes, ma'am, yes.
If an employee requested a personal holiday before a personal holiday following after July 1st, 2023, but they made the request prior to June 20th of 23, would they be requesting something that had been approved by the Board of Commissioners?
Requested prior to the June 20th adoption of the board of commissioners, if they had requested something that would get denied because the board had the ultimate determine if it would be given a personal holiday.
Is the personal holiday something that is guaranteed for all employees every year?
No,
How is a personal holiday established?
and our organization, based off the newly amended policy, and it's treated like any other request for annual leave, and it has to be submitted 30 days in advance.
In granting personal holidays each, how do you know if a personal holiday is going to be allowed in any given year?
We have to wait for the board of commissioners to.
So that's something the Board of Commissioners considers every year on an annual basis?
Yes.
When you are approving leave requests of whatever nature, what factors do you or your staff take into consideration in evaluating whether a request will be granted or not?
First and foremost, looking at staffing for that day, that calendar is already full, and no more requests for leave will be granted due to the minimal staffing measures that we must maintain in the program. If the calendar is not full, then it goes based on 30 days in advance.
Look, if you would, at Exhibit C6. Can you tell us what that is?
Policy 207, which addresses our minimal staffing budget.
So if you already have more people scheduled to be off for whatever reason, a request coming in, even if it came from the most senior person on the shift, that would be denied. You're not going to keep off a lower seniority person who already has approved time off for that day just because you get a request from a higher ranking in seniority employee. Is that right?
That's correct.
Are there certain kinds of leave that take priority over other kinds of leave?
Yes, sir.
What are they?
First and foremost, as the ship operation leadership begins to load the upcoming calendar, we must ensure we meet the FLSA requirements, which is a calendar day that must be placed on the calendar for that entire operational ship before any other day.
You said FLSA requires K days. How often are K days required?
It's roughly every 3 months.
Look, if you would, at Exhibit C7, please, and tell us what that is.
C7 is the contract on emergency services 28-day FLSA calendar for calendar year 2020.
Why is it on a 28-day cycle?
Our works a 24-48 schedule based off FLSA. We follow the 28-day calendar, which means every 28 days, employees are only allowed to work 212 hours before we have stated.
Is that how a K day comes into play?
Yes,
And you said that is under FLSA, so it is federal law that mandates you give K days, is that right?
yes, ma'am. And once again, those must first go on the books to ensure that we follow that federal.
Why is 30 days considered advance reasonable notice in the fire department?
Staffing changes daily. We have no control over things that happen, such as FMLA deployment when it comes to our military servicemen and women on the ground injuries. So staffing is something that can change in the blink of an eye.
So is it fair to say that in July of 2023, you're not going to know what your staffing levels are going to be in May of 2024? So you establish your K days, but when it comes to other days off, that's why you ask for it to be submitted closer to the time they want to be off. Is that fair?
Yes, ma'am. Given the 30 days, the shift leadership and range of that calendar has a better understanding of their staffing 30 days out as compared to 6 months out.
Your knowledge, has Sergeant Sherritt ever not received a personal holiday in any given fiscal year?
For the last 5 years, he has not.
If you would, exhibit C13, tell us what that is.
C13 is the workforce telestat, which is our scheduling payroll calendar. For the pay period, December 15th, 2018 to January 30th of 2024. The start out history for Sergeant Kyle B. Sherritt, working with unemployment, and list out the 5 days over the course of the last 5 years where he was given his personal holiday.
That's all I have this time.
Mr. Sheriff?
No, we can ask questions.
I'm sorry. Any questions from the board?
I have none.
I have none.
Mr. Smith?
I don't have any.
Can I call my next witness?
Next
Uh,
witness,
Captain Adams, please. Captain Adams, please.
Captain Adams. Morning.
Morning, Captain Adams. If we follow along in A8. In A8, this is our email correspondence between us both. You use phrases like total and complete transparency. And every member of B Shift has access to the calendar 24 hours a day, 365 days a year. Do you believe that the calendar, which is in C12, is up to date and accurate? It would be a copy of what we currently have from the 2023/2024 vacation calendar year.
Tell me your questions a little clearer. I don't.
Sure. Is the calendar that's listed accurate?
I don't know. I don't have any.
C12 is a copy of our 2023/2024 B Shift K-Day and vacation calendar. It's listed in its entirety under C12. Does it resemble the one that you created?
It resembles it, yes.
Would you have any belief that this isn't the one you've made?
Right now, I don't have a reason to think it's not.
Thank you. I've looked through C12 and counted out who is coded for 85. There were 32 personal holidays coded 85 used in that calendar year, which equates to about 28% of B Shift billets. Were you aware that only 32 people were able to use their personal holiday according to this record?
Okay, so this is the current calendar. You're saying there were 38.
32 people were coded as 85 according to this record.
And the question is.
Were you aware that only 32 out of 115 billets were able to use their personal holiday?
I was not aware of that.
Understood.
It's not something I track on a daily basis.
I get that. In the C12, the calendar that you created, were you aware that your office denied 36% of all 30-day out requests? In other words, there were 41.
Challenge the accuracy of the numbers. I'm not sure.
You'd have to go through the data. So C12, if you look at each individual one and were to go through,
Numbers. We could know those are accurate numbers.
I had to count them in the exhibit that was given to me. And I counted 41 out of 113 that were denied.
I'm not sure how accurate that is.
Would there be any reason to believe that I'm lying about the numbers I found within the exhibit? You don't have to agree with it, but do you believe I'm lying?
I don't know.
Understood. According to a resolution, and that's found in C4. Each county employee shall request the date that he or she wishes to observe July 1st, 23 through June 30th, 2024 fiscal year. Is that your understanding that each county employee shall request?
Is that my understanding of the resolution?
Is your understanding that the personal holiday has to be requested by the employee?
That's what it says.
Thank you. In A4. This is in reference to the PAC portal question that I requested, that Chief Sweat answered. And in that statement, in that reference, he stated that he would take corrective measures if necessary to supervisor were assigning personal holidays. Have you personally assigned personal holidays?
Ever?
Sure.
Yes.
Is it your understanding that the resolution in A4, that if a personal holiday was not used in that fiscal year, that it would be forfeited?
Does the resolution state that?
Yes, sir. C4. Yes, sir. It would be the second last page above the section says section 2. If it's indulges, I could read the personal holiday must be observed. Okay, thank you. A5. This is a correspondence between you and I about a request for a personal holiday. March 23rd of 2023, I requested a personal holiday for July 9th, which is more than 30 days out because at the time that was the current resolution. At the time of the request, there were 2 vacancies available.
Can I pause you right there?
Sure.
You said that was the current resolution?
At the time of the email, before the county changed over policy, reasonable notice didn't have disclaimer of 30 days out. It was just reasonable notice. That's why the discrepancy from March till July, because that would be more than 30 days out for the request. The thing is, I was denied for that request because of due to staffing levels in the email. Would you stand by that statement that I was denied because of staffing levels for that day?
Yeah, so according to my email, that was the false, but not.
Thank you. According to C12, which is the calendar, are you aware that you approved a less senior man for that personal day that I was denied because of staffing?
Let's stick with it.
Sure. C12, July 9th, I believe. You have Lieutenant Hatfield in the 11th spot. You have a complete vacancy in the 5th. And Lieutenant Hatfield at this time has less seniority for me, but received a personal holiday.
Do you have documentation of
When he requested his personal holiday, so you'd say that, do I have Lieutenant Hatfield's email?
Yes.
I apologize, can't introduce it. I only have, you're right. I just have a text ask. Yeah,
Both sides.
I spoke to, do you believe
No, I don't believe it if it's not.
that Lieutenant Hatfield was assigned that day?
I can't speak on it. There's no exhibit. You're asking about something I was not.
You're right. I did have a conversation with Lieutenant Hatfield. Would I be lying to say, would you believe that if Lieutenant Hatfield said to me, he was assigned the personality, that I'd be lying?
He's not.
Yes, ma'am.
Are you testifying? Do you have a question?
I was asking if it's possible that I had a
It doesn't
conversation.
sound like you were asking, you were telling him something, and you're an intelligent man, so don't play upon the intelligence of this board.
Yes, sir.
Ask a question. And you know how to ask a question,
Yes, sir.
so why you wanna play with us?
I'm trying to get to the root of that.
Ask a question.
Sir, C12 is the calendar year. Lieutenant Hatfield shows up on July 9th and 23rd. Does that issue him 2 personal holidays within a fiscal year according to the calendar?
You said July 9th and what?
December 3rd, 2023,
You said he shows up on both days.
as 85, which is coded as a personal holiday,
You said December what?
December 3rd.
Okay, and your question is?
Did you issue Lieutenant Hatfield 2 personal holidays within a fiscal year?
Again, Mr. Sheriff, you're asking me to answer a question about something there's no documentation to support. This
It
is
doesn't-
This is a calendar, a live calendar that we use to plan things out. It's not payroll. It's not how people are paid. It's not how people are coded in Telestaff. Unless you have those documentations, I can't answer questions about something that can change every hour.
Understood.
You are aware this is a live document and it changes based on people leaving, us hiring people, people submitting time trades, people requesting to swap days. This is the template we work off of. You could have put in a request to have the official coding for everybody for the entire year. That's not here. I can't answer questions about things that are not here.
Lieutenant, sorry, Captain Adams, do you remember the first question I asked if the calendar was accurate?
At the time you printed it, it probably was, but it changes. It is a live document. It can change. I can pull up on my phone and change it right now if I need to.
So your testimony that when this was printed, it was accurate?
I don't know.
Yes, sir. Do you see that on July 9th and December 3rd, he is coded for 85?
I see that on this document, he is coded 85 above.
Would it appear to this document, just to this document, when the printed form, that he got 2 personal holidays within a given year, just
No.
according to the documents
I
code?
can't answer a question about that.
Okay,
This document doesn't say what anybody received. We have
understood.
official documentation for that. This is the template that we work off of for vacation and scheduling purposes.
With the limited request for personal holidays, are you concerned that, say, a personnel may call in sick and then just request that it be changed to their personal holiday? Or is that a concern at all?
Ask the question again, I'm sorry.
If a person felt that they were having difficulty getting their personal holiday accepted, would you be concerned about someone calling in sick and then requesting their personal holiday to be swapped out for their sick day?
You're asking me to speculate about somebody's motives for taking a day off?
No, sir, I'm saying, is that a concern? Do you see it as a possibility that that could happen?
There's so many things that are possible.
Understood.
I don't understand what you did.
On A5. This is a correspondence about the personal holiday requests that I made on 2 separate occasions, one for July 9th, the other one for December 27th. I received denials for both of them. But when I did request on A7 to change a sick day that I had into a personal holiday, you approved it. Do you recall that? A7 is the approval of substituting my sick day for a personal holiday.
Yes, I see it.
Thank you. Do you believe that we have a little bit of an attrition problem? I'm not saying more than any other fire department, just attrition in general. Is it a difficulty? Basically, because you're doing operations.
When you say we, you mean?
The department as a whole, all 3 shifts are having difficulty staffing because of attrition. No blame to the department. It seems to be a nationwide issue. Would you say that's difficulty to maintain minimum staffing because of attrition?
I would disagree. We do a pretty good job at taking minimum staffing.
Thank you for your time.
Captain Adams. Looking at A7. Sergeant Sherritt was just asking you about, do you have any idea how it is he knew on November 2nd that he was going to be out sick on November 27th? Is it possible that he had a scheduled medical procedure?
It's possible.
Is it possible that he was out on workers' comp?
Actually, yes, when this whole crusade against the fire department started, and shortly after Mr. Sheriff went out of workers' comp, he's been out of workers' comp since May of last year.
So if someone is on scheduled sick leave for a reason like FMLA or workers' comp, something like that, does that create the same kind of concern that he was just asking about if someone randomly called out sick and then asked you to change it to a personal holiday?
Yes, ma'am.
If you began to see a pattern of employees calling out sick and then asking for that to be changed to a personal holiday, what would you do?
Think the pattern, we would deny.
At some point, would you become concerned about the truthfulness of the employees who were doing that?
Yes, ma'am.
Is that a violation of department policy?
Yes, ma'am.
Is it a violation of civil service rules?
Yes, ma'am.
Does it create disciplinary issues for the department if employees choose to take that course of action?
Yes, ma'am.
What is your current duty assignment?
I am the beat shift, operations captain. I'm in charge of scheduling, and I work as sort of a liaison between all the different divisions in the department and beat shift operations.
And how long have you held that position?
Roughly 7 years.
We've looked at exhibit C12 before. I believe you told Sergeant Sherritt that you had created a spreadsheet
Yes,
like this that is used to schedule leave time.
yes,
And Chief Sweat has already testified that K days are scheduled first. Is that right?
yes, ma'am.
And that is how you in fact schedule leave time. Is that right?
Yes, ma'am. It's the law.
And then once K days are scheduled, is there any sort of pattern or priority to the way you schedule other leave requests?
Yes, ma'am. We have technically 3 phases. Phase 1 is 10 days, where every employee is assigned 10 days for the year. Phase 2 is a 5-shift vacation, where employees can choose any 5 shifts they want throughout the year and request those all in advance, a year in advance, so they're well aware of their calendar, they can make plans. Phase 2 is a 3-day vacation request.
And then beyond that, is that the 30-day?
Yes,
Request.
anything after that is submitted 30 days out.
Why do you do it in phases?
So it's fair, so that, you know, people like, so, Mr. Sheriff said he was number 1 on the list. The people with more seniority can't just take up the entire calendar. Everybody gets an opportunity to get days off.
How many billets are there on B shift?
Current staffing?
That was my next question. So how many,
5. I don't know the number of current billets off the top of my head. Good question.
is it fair to say that you almost always have some kind of vacancy on your shift?
Yes, ma'am.
Are you constantly recruiting for firefighters?
Yes, ma'am.
So even if you had 100 billets, you have 95 employees.
Yes, ma'am.
Is that sort of the average of where your employment level stands
Yes, ma'am.
in your experience?
Yes.
Does that affect how many employees can be off on any given day?
Yes, ma'am. So, right, you said 95 is a great number. It takes us 84 people every day to run a shift.
Look, if you would, at exhibit C10. And you'll see at the bottom of that first page, it says it's time to submit your 5-shift vacation request. Do you see that?
Yes,
So is that how you handle scheduling for employees for the phase you just discussed with the 5-shift scheduling?
yes, ma'am. This would technically be a phase 1 email
Okay,
that comes right after the K-day phase.
so then back up to exhibit C9.
Okay.
Is that the email where you're scheduling K days?
Yes, ma'am.
And so do you solicit input from your employees as to what days they want SK days? Look at exhibit C8. Can you tell me what that is?
This is the K-day cycles listed for the entire operations, all three shifts.
All right, and so if you're on B shift, that would be the middle section that's highlighted in red.
Yes, ma'am.
So those are the dates where you have to assign a K day to each employee on your shift. Now look at C11, please. You talked about scheduling K days and then a 5-day vacation and then a 3 shift vacation. Is that what exhibit 11 is doing?
Yes, ma'am.
Now, when you send those emails out, do you send it to everybody on the shift?
No, ma'am, these are just a block of people, based on the service department. It gets sent out to whenever it's your turn, whenever it falls within your block.
So is it fair to say you would ask, say, the first 10, the highest ranking in seniority, the top 10 folks to schedule their whatever phase you're in, whether it's K day or 5-day or 3-day,
Yes, ma'am. Typically, we'll start with the top 20.
and then you would go to the next 20, and then after you make it all the way through the roster for that particular phase, then you start over for the next one. Is that right?
Yes, yes, ma'am.
Look, if you would, at exhibit C14, please. And can you tell me what that is?
This is we were talking about length of service, seniority list.
Okay.
When I say seniority, I mean length of service, how long we've been with this department.
And so that's what you attached all these emails that we've just looked at that we're scheduling.
Yes, ma'am.
And once you complete the responses to those 3 emails, the K day, the 5-day, the 3-day, then all of the leave requests, I think you just said were completed on a 30-day advance notice.
Yes, ma'am.
And why is that 30-day advance notice required?
As Chief Sweat indicated earlier, our people are very vulnerable to injury. We have families, things come up all the time while people can't come to work. So it'd almost be negligent to start giving away days, not knowing what's gonna happen. Closer to the time that a request is needed.
You're familiar with policy 1046, is that right?
But
That's exhibit C5. So prior to the implementation of this policy, how were personal days assigned?
after we finish, so the K-day, phase 1, phase 2, we would, starting on, as soon as the board would approve the personal days, we would take the first day of everybody's vacation, starting the first shift in July minus the 4th of July holiday. And we would assign them their personal day to guarantee that they were able to get it.
So rather than coding it for annual leave, you would code it for personal holidays. Is that right? Okay. Do you know why that policy changed or that practice changed?
I believe to fall more in line with the board's resolution.
Now, when you receive a request for either a personal holiday or annual leave that's within that 30-day window, how do you determine whether it's going to be granted or not?
It's based on length of service. Seniority is.
So if you got 3 requests 30 days out, what is today? This is February 28th. So if you got 3 requests today for March 28th, you're going to look at the seniority of the people making that request.
Yes, ma'am.
Do you look at any other factors for what's already scheduled on March 28th?
Yes, ma'am. Calendar. We have we can only allow so many people off per shift.
So if you already had K days or leave that was scheduled during the 5-day and or 5 shift and the 3 shift scheduling on March 28th, you wouldn't cancel somebody's leave to be able to give a personal holiday for a request that came in today. Is that right?
No, ma'am. Once the calendar, once our vacation,
Mhm.
the days, the phase 1 to phase 2, that's set. We promise our people that. So it's not gonna be taken from them.
To your knowledge, has Sergeant Sherritt ever not received a personal holiday in any given fiscal year?
No, ma'am. We always.
to your knowledge, has anyone else not received a personal holiday in any given fiscal year?
Not to my knowledge.
Are you aware of any questions raised by any employees about the previous practice of coding the first scheduled annual leave day as the personal holiday?
Over one. Who's here now, but other than that, I'm not aware of anybody else.
Has Sergeant Sherrod ever discussed his request with you? Has he discussed his grievance about this policy and the implementation of this policy with you? Okay. That's all I have at this time.
Any questions from the board?
I have none.
None.
Mr. Smith?
I have none.
Witness excused.
As far as I'm concerned.
Yes, ma'am.
Do you have any more?
No, ma'am.
You have no more witnesses, Mr.
No,
Chair.
ma'am.
Do you rest your case?
Yes, ma'am. Miss-
We recall Chief Sweat.
For the record, Ms. Youngblood, you have 7 minutes and 43 seconds left. Mr. Sherrod, you have 9 minutes and 26 seconds.
Thank you, ma'am.
Chief Sweat, can you tell us why you changed from the previous practice of coding the first day of scheduled annual leave for a personal holiday?
Yes, ma'am. So I think it's also important to note that for civil service, the county graciously approves up to 15 annual leave days for all county employees to take at their discretion. Via the adopted resolution, the personal day is a sick leave day. Via that resolution, it is a benefit to the employees who are out there that in the best interest of the employee, that they be given the right to choose their day. And to moving away from the previous practice where it had just been signed.
If an employee wanted their first scheduled annual leave day to be treated as their personal holiday, is that something that you would do?
After the board had adopted for that fiscal year, sure.
And did you implement this policy 1046, speaking to personal holidays in response to questions or concerns raised by employees?
Yes, ma'am.
Thank you, that's all I have.
Sir, just one question. How does changing the resolution to clarify as 30 days out benefit a firefighter other than reasonable notice?
So once again, as from the other stated, the board does not define reasonable advance notice. Once again, that's every department in this county is different. We all have different needs, unique circumstances, and we all have different responsibilities to the community that we serve. So therefore, I have elected, given the current practices of the organization, to put that in line with any other requests, such as annual leave, which is redefine reasonable notice as 30 days.
Reasonable notice, would you say, was more than 30 days in advance before you did the clarification?
No, because once again, annual leave days in the current policy, as well as the previous policy, has always been 30 days.
Thank you, Chief.
Any questions from the board?
No, I have none.
None. Mr. Smith?
Yes, let me, excuse me, let me just get a little bit of a clarification. Can you hear me okay, Chief?
You can speak up a little bit.
Yeah,
Speak up a little bit.
Yeah.
Okay,
I
How about
did
now?
Turn up the volume a little bit. I think if we turn up the volume in here, we can hear better.
okay.
That doesn't have to yell.
Alrighty, how about now?
Hold on, IT's just now getting in here.
Okay,
Okay, keep talking so we can see what the volume is.
okay. 1, 2, 3, 4, 4, 3, 2, 1.
Okay, it's better.
Okay.
Thank you.
Okay, okay, just a little bit of a clarification. I know Captain Adams testified that he was not aware of anyone losing a personal holiday since the institution of this. Are you aware of anyone?
To my knowledge, no, sir, I haven't.
Okay, and excuse me. So to Mr. Sherritt's grievance and what he writes out to ensure an employee ability to utilize their personal holiday. For your information and from Captain Adams' information, every employee that you know of or are aware of have actually used their personal holiday, been able to utilize it, whether it was in conjunctive with a annual leave day or sick day. There was some kind of, lack of a better word, some kind of wrangling to fit it in so everyone was able to utilize it. Is that a fair statement?
Yes, yes, sir. It's a benefit by the board, and it's the goal of the organization for the employee not to lose that personal holiday. So we're going to do the best that we can to ensure they don't. It's an additional benefit, gives them a 16th day off.
Okay, and also coming from a previously a kind of a large organization, sometimes it's just the employees' absent-mindedness that personal holiday is not utilized. I know at the sheriff's office it happens. Sometimes people just forgot about it, and it was just one of those things. It wasn't anything the agency did. There was no denial, but it was just a thing that they just forgot to put in for. But when and I guess it's more of a statement. From your information and from Captain Adams' information, there hasn't been anything, so we're addressing a problem that's not a problem. Just a statement, that's all. It didn't require a response. Thank you, sir.
Swiss witness excuse.
Well, he can't go anywhere. He can come back and sit down here. Yes. At this point, we would tender exhibits C4 through C14.
Shared objections.
No objections.
Do you have any documents you wish to tender?
No, ma'am.
Adjourn to executive session. Motion to adjourn to executive session.
Can we make some close?
Oh, I'm sorry. Retract.
It's okay. Pretty simple. As Ms. Youngblood had referenced, I've never missed my personal holiday. It's because I'm a senior man, I actually have a bunch of benefits that for the most part, if there's going to be a day off to request, I'm going to get it. This was more meant for the less senior people who are struggling to get time off and to not have them be put in the back line for a request for a more senior man. Trying to find, like what Captain Adams referenced, is that when they put out the vacation calendar, it's not to limit the amount of time you can have for a less senior person. There was just something that's on the books. C12 has only 32 people, it has coded as 85. It's the only proof I had that not everyone got their personal holidays. And as the chairman had said, is that some people just forget that this benefit exists. And a time to have time off, I'm just trying to bring it to the forefront. This doesn't benefit me. If anything, it would limit the amount of time that I can take off because other people would have more time to actually put in for it. This is not about what I can do. This is just about returning it back to the resolution adopted by the county, not by the department. Thank you.
Thank you.
Ms. Lancaster, can you confirm my time, please?
6 minutes and 29 seconds.
Thank you. As Mr. Smith noted, we apparently have spent a good hour this morning on a problem that's not a problem. Sergeant Sherritt just told you he's never missed his personal holiday. But he's the one here grieving a policy that he has just told you didn't really cause a problem for him. There's no evidence that it's been a problem for anyone else. The only evidence you have before you is that everybody, to the knowledge of the command staff of the fire department, they've gotten their personal holidays. The policy that Sergeant Sherritt is complaining about in Exhibit C5 is almost verbatim Resolution 2023-134, which is Exhibit C4. The only language that varies is the definition of reasonable advance notice. The resolution itself contemplates that each department will establish what constitutes reasonable advance notice. And that is exactly what the fire department did. They established reasonable advance notice as 30 days in advance, which is exactly the same as the advance notice requirement for other kinds of leave, and the same advance notice that has been required by the department under previous policies that has been both policy and practice for many years. And you've heard evidence that the department goes to great lengths scheduling things in phases to ensure that everyone on the roster gets to use leave time, that they get time off that they have requested. They don't schedule every single day that the most senior ranking or most longest seniority, longest tenured employee may request, because that might deprive the least senior employee of time off. So they schedule it in phases. They go through these rotations to ensure that everyone gets their time off. There's no evidence before you that this policy that is being grieved has affected anyone's use of their personal holiday. As I said, with all due respect, it seems to me like we've spent a lot of time wasting people's time this morning complaining about something that's not a problem for anyone that's here before you. If it had been a problem for someone else, they could have grieved it and they didn't. So based on the evidence that is before you, I submit to you that the policy is appropriate, that it complies with Resolution 2023-34, and we will ask you to deny the grievance.
Madam Chair, I move we adjourn to executive session to discuss the merits.
Second. All in favor? Aye.
Aye.
We're in executive session. 10:22. February 28th, 2024, back in session at 10:35 a.m. Dr. Jackson, motion?
Madam Chair, I move that we deny the request for that we would deny the grievance at least.
Second.
All in favor? Aye.
You muted, Mr. Smith.
Motion has been carried unanimously.
Okay. Thank you very much.
Thank you, sir.
Thank you for your time.
Madam Chair, I move for a 15 break while we prepare for the next case.
Second.
All in favor?
Aye.
Aye.
Be in recess for 15 minutes. Civil Service Board hearing, February 28th, 2024, back in session at 10:47 a.m. IT, please start recording. This is the case of Shalonda Riley, Magistrate Court, termination appeal, filed November 15th, 2023, regarding my termination on November the 7th, 2023. All witnesses
Yes.
present. Swear in the witnesses.
Do we have them in?
Yes.
All those planning on testifying here, please stand, raise your right hand. You swear or affirm the information and testimony.
Ms. Riley, are you gonna testify?
No, I'm just gonna present my case.
Okay.
Do you swear or affirm that the information and testimony you're about to receive or about to give in this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Do you, either party wish to have the witnesses question?
No.
This is a 90-minute time limit hearing. Each party will have an opportunity to provide opening statements, examinations, cross-exam, and closing arguments. Ms. Lancaster will be our timekeeper, so if you're in need to know how much time you have, just ask her. The county, since it's termination, I guess you go first.
Yes, ma'am. In November of 2023, Chief Judge of Magistrate Court, Judge Keisha Wright Hill terminated the employment of Chief of Staff Shalonda Riley for a variety of performance issues. There had been personality conflicts that prevented her from supervising staff in the magistrate court that was part of her duty as the Chief of Staff. She had made disparaging remarks about the court in the presence of others. She was insubordinate to one of the other judges, as well as to the chief judge. She was not producing a work product that is what you would expect from someone at a chief of staff level. And critical time-sensitive tasks were not completed in a timely manner. Things like scheduling judges for the magistrate court were not completed in a timely manner. As a result of all of these performance issues, which had been discussed with her by the chief judge on more than one occasion, her employment was terminated, and at the end of this hearing, we will ask you to uphold that termination.
Ms. Riley, your opening statement.
Yes, ma'am. Mental illness is not an easy thing. It is a condition that affects mood, thinking, and behavior.
Excuse me, would you speak into the mic?
Sure.
Thank you.
Mental illness is not an easy thing. It is a condition that affects mood, thinking, and behavior. There are different types of mental illness, such as depression, anxiety, post-traumatic stress disorder, and et cetera, et cetera. I have a history of mental illness. On February 18, 2011, I lost my parents, Corrine Riley and Colonel Riley, to homicide-suicide. Please direct your attention to Exhibit A1, the obituary.
Sorry,
And-
I don't have any exhibits.
Steve.
Yeah, that's it. So what was your?
I've objected. I don't have any exhibits from the appellant.
This is a chance for you to tell us what your case is about, not to go into evidence. And at this point, we don't have any exhibits that you are referencing. So.
Okay, did you all not receive the exhibits that I submitted?
We did, but this is an opportunity. In your opening statements, you're just gonna tell us what your case is, what you plan, what your case is about. Not to delve into particular issues.
Evidence and all that. Tell us what you expect from this board, which we like this board.
Okay, I'll continue without mentioning the exhibits.
Now, you'll have a time later on to mention.
So you have 90 minutes to do that. Right now, you're just giving us a preview,
Overview.
the introduction.
Okay, so basically, what I want to state is that even if what the county is stating about my poor performance, if I had been performing poorly, I didn't get any written documentations of it. I didn't get any opportunity to correct the performance issues by giving me a performance evaluation in September of 2023, so that these issues can be corrected. However, because I had a mental illness situation to happen to me with my divorce in 2023, along with my prior issues that I've had, I took a leave of absence from work and I filed it up on the Family Medical Leave Act. When I returned back to work, I was demoted from chief of staff to office coordinator. And according to the United States Department of Labor, FMLA law, when I return from leave, I am required to be made whole, meaning I should return back to the same position same title, same duties, same tasks, or the equivalent of those duties when I return from FMLA. And those FMLA rights were violated once I returned a day from leave and I was demoted, placed in a new office, and told that I would report to Judge Kate Johnson, and I would no longer report to the chief judge. So I'm asking today that you all overturn this termination because it was a wrongful termination and also a violation of my FMLA rights.
Thank you. Ms. Youngblood.
We call Judge Kate Johnson. Yes, ma'am.
Good morning.
Would you say your name for the record, please?
Presiding Judge Latrivia Case Johnson,
And you're the presiding judge in which court?
Magistrate Court,
How long have you been presiding judge?
a little over a year now.
And did you have other experience as a judge prior to becoming presiding judge?
Yes, I was just an associate judge.
And how long were you an associate judge?
2020, Judge Rikers Administration, so 3 years, this will be our 4th year. 1 year as presiding.
And so as an associate judge and then presiding judge in the magistrate court, did you have occasion to work with Ms. Riley?
Yes, I work with Ms. Riley quite a bit.
Would you tell the board about your experience working with Ms. Riley?
Well, when she came on, we were really excited to have a chief of staff. She began working really hard, actually. She was coming in, it was amidst COVID, so a lot of the staff was working at home. So I guess that really her communications with them was more so online or email. Once we started transitioning back to the courthouse, and it began where Ms. Riley and the employees didn't have a good relationship. I would constantly hear the things that she would say to them that was inappropriate, disrespectful, demeaning to the court. And so it had become where they wouldn't go to her, they would now come to me, and as presiding, I'm already managing the judges. So at that point, I had to assist now with managing the staff, the digital support staff.
You said you manage the judges. How many judges are there in magistrate court that you're responsible for?
Additional is 8. I know it's 4, 3 other than myself, it's 4 full-time, so I manage 2 full-times, and then the rest 7 part-timers.
And how many staff are there in the office?
There is a JA for each staff, so that would be 4 judicial assistants. We have an extra, what we call a project manager. So I would say in all, with the legal assistant, the legal secretary, with a receptionist, we're probably talking 8 to 10.
Are those all full-time employees?
They're full-time, but some of them are contracted, some of them are.
So can you give the board an example of the kinds of things you would hear Ms. Riley say that you found to be disrespectful or demeaning?
The first incident I've had with Ms. Riley is where we were, a couple of our judicial assistants, and so her responsibility was to make sure we had proper coverage. And so my system, which is Ms. Riley asked her to cover a duty that she should not have asked her to cover. It's because she didn't understand doing these 2 duties together would be virtually impossible. And so I tried to explain to Ms. Riley that, hey,
you should not have assigned her that because she's doing this. You should have probably asked, and that time it was Miss Mary Moultrie, if she could do that, because Miss Thomas is gonna be completely overwhelmed. Well, because Chief Bradley, even at my urging, never took the time to learn the jobs of these employees. She didn't understand what they do. And so because she didn't understand that, she thought I was interfering with her role. She called the chief judge and said, she's giving them direction that I didn't give them. I backed off. Lo and behold, it turned out bad because my judicial assistant could not manage all of it. She ended up working till 8 o'clock that night. She was frustrated. But this is what we were trying to tell the chief, is that you just can't do that. And so she called the employee and said, you're gonna do it because I said you're gonna do it. And so we ended up having a meeting with the chief. And the thing, we have a chief that's gonna give you the benefit of the doubt. And so we talked about it. Unfortunately, Ms. Robbins stuck with her decision, and she said, I told her to do it, and I just want her to do it. So that was the first thing. And so I talked to the chief, and I said, I think that we need to have her trained on everybody's positions, so that she'll understand when she's rearranging duties, what she should have people do in conjunction with other duties, and what she should, and what it entails, and how long it takes, and what it takes to fulfill that duty. And so I think that there should be some training involved. I know that there was some attempt, but as I said, the employees then started just coming to me, and she wasn't interested. Specifically, it was said to me that she said that she don't get paid enough money to do their job, and so she was not interested or trained for it.
Were there any other duties that you believe she should be trained or should learn how to do that she refused to learn?
So once Chief Hill had a conversation about all the conversations that were coming to me from the staff, the chief and I spoke, and the chief at that point talked to all the staff directly. And she talked to them about what's going on, what do we need to do, what's the problem? And then at that point, they communicated just a lot of things, and it made her very upset to hear the things that was communicated to her by the staff. At that point, the chief made a decision, Judge Hill made a decision that she needs to come off of managing the staff. So that we took that role from her altogether. Judge Hill took that on herself. At that point, we needed to give her some additional duties now, because she had some time and we had taken away a large portion of what she was supposed to be doing. Judge Hill, one of the things that we suggested was what we call civil trial prep, and that involves going into the court system, a software system, and you'll print the complaint, the answer, and service, so that the judge will have this information when they're in court, when they get into court. So I actually wrote up all the process. I made it real pretty, really colorful. I'm a colorful person. Wrote the step by step. Judge Hill had directed me to do this. I go in my office. I asked if she had a moment. She came in, and we were at the round table that's inside of my office, and I'm reading to her the instructions, telling her how detailed they were. And I look up and she's gone. And I was like, maybe the chief called her. And so I walk outside of my office and I see her leaving, going down the hall. And I said, at the time, her name was Sanders. Chief Sanders, what is going on? I'm not doing that. And she raised her, she flew her arm. And I was like, are you serious? And so, as I'm walking out, all the employees now that were sitting at the desk are now standing at their desk. And everybody's saying, what's going on? One of the employees said, well, she almost knocked me over coming out of your office. And I didn't understand. I said, well, she's not my employee. trying to follow direction. I just went to my computer, typed up what she has done. I said, Judge Raphael, that you instructed, I attempted to train Ms. Riley on this. She walked out of the office, she said, we were doing it. I just wanted you to know.
As chief of staff, did Ms. Riley have the authority to countermand an instruction given by a judge to the staff in your office?
Generally, she is responsible for, she's over the judicial staff. In my opinion, because the staff work directly with us. Although the chief, she delegates different other, but when it comes to what the staff does for us, we have the last say. Because every judge does things differently. They may, like for me, I may have my judicial assistant do all of my orders. But for another judge may say, I'd like to do all of it. So as far as our judicial assistants, our say so, was it.
Are you aware of any occasions where Ms. Riley gave instructions to staff not to follow the directions given by a judge?
In the communication that I've had with the employees, so going back into, trying to go back into the courthouse after the pandemic, we had to make a lot of changes. And understandably so. And so the changes that were being implemented, Ms. Riley didn't like them. She disagreed with them. And so she would have meetings with the staff and she would communicate the new change, but she would make it clear to the staff, which is totally unprofessional, that it was my doing, that y'all need to thank Judge Case Johnson for this. It makes no sense. She even told one of them, you better watch your back, Judge Case Johnson. And so it's almost like if the employees were in the middle and they were being pulled.
In addition to the meeting that you had that she walked out of, were there other occasions where she did not complete tasks that you had assigned her?
Well, there are a number of things. So I get my judicial assistant locates a stack of orders, motions, and those things are very important. They are asking for their clients to be put out, get out of jail. It could be to modify a bond condition. It could be asking for their money, but whatever it is. And so if judicial assistants don't understand where to go with that, they give them to her. Well, lo and behold, they just finally brought me a huge stack of orders that were given to her that were never processed. That caused quite a bit of backlash on the court. Because now here we are reaching out to these attorneys and they're saying, I filed that 2 months ago. I filed that 3 months ago. And there may have been something wrong with it. But we didn't even get the opportunity to fix it or even tell them what they needed to fix because we didn't even know about it. It was sitting in her office. That's one thing. I also asked her to draft in her new role. I asked her to draft a memo to the judges. I pretty much hand wrote what to say. I was asking her to make sure the judges understand the difference between liquidated damages and unliquidated damages. Because sometimes they can kind of overlap, or you can get, sometimes our judges can get confused as to what facts is for what. So I asked her to compose a memo. I gave her the information. She composed it. The information was correct, but it looked so unprofessional. It was something that I completely took and redid. There's no way I was going to get it out.
Direct your attention in that binder to exhibit C9.
Okay.
Can you tell us what that is?
This is the memo that I was the first review. Liquidated damages versus unliquidated damages.
Is that document a memo?
It is,
But this is what she provided to you in response to your directive to create a memo. Is that right?
yes. The fonts used was unprofessional, the different colors. This was supposed to be a professional memo. Also, I asked her about putting some information in her new role. I was gonna give her where she would have to go and look and see CPUA as a system that we use to determine things such as if a case had been closed, if an answer had been filed. 3 years in, this is our 4th year, she didn't know how to use the system. She didn't know how to, she may have understood how to sign in, but she absolutely did not know how to use it. And that is a critical part of our entire, it is the basis and the foundation of our department. This software is used every single day, all day, and especially used more often than with the staff rather than the judges.
Did she ever give you any indication as to why she had not learned CPU 8?
Well, initially she said in a meeting that she did know CPU 8, but then in her new role, when I was asking her to do certain things, it was very evident that she did CPU 8.
Did she give you any indication as to why she didn't know?
Well, I mean, it was a common comment that was made about she didn't make enough money, that wasn't her role to understand the jobs of the JAs.
Direct your attention to exhibit C5, please. Can you tell us what that is?
I guess it was supposed to be something that she was obviously having a party and she was printing out the welcome to wherever, I guess, wherever she was gonna do with that. This was her welcome flyer.
And where did you locate that flyer?
It was stuck in the machine, the copy machine. I had gotten to work early. It was the day she came back from her meeting. And I wanted to prepare for her and talking to her about her new job duties. And as I was printing some things, there was something stuck in there and I was able to pull it out. And that's what it is.
And you mentioned earlier that part of your duty as presiding judge is to manage the other judges. Does that include scheduling the part-time judges?
No, I didn't. It wasn't my job to schedule the part-time judges. That was Miss Riley's, or Miss Riley now. That was Miss Riley's job.
And is that something that she completed successfully?
It would often be, where they would actually just move things around themselves. Because we have a very competent staff. And so they would kind of just do things that they knew would be better. And so they would just change it on their own. But me particularly, something very important, one of the most important roles that she had is to create the rotation or what we call a master calendar for the judges. And so we'd like to have those a year in advance because we have so many judges. And so we needed these judges to have this calendar so they can plan around, they can do their vacations. And so I sent her an email and I said, hey, I need a year of these calendars. And I gave her like 10 days to do it. It may have been a little more. And at any rate, the day before the deadline, she emailed back and said something, I'm not able to do that. Or it didn't happen. And so at that time, I really had to pick up the ball. Now I am assisting with managing the staff, I'm now managing judges, I'm now doing, so a lot of her role now, her responsibility, I've taken, I've had to take.
Direct your attention to exhibit C8, please.
The number 8,
Yes, and tell us what that is.
this is the master calendar.
So that's what you're referring to, that it was her duty to create that she did not.
Yeah, she created like 2 of them, 2, maybe 3 for the year. But it may have been just 2, I believe she just did January and February. And she was asked to do all the way to December.
In addition to the things that you've described, are there any other issues you had with her performance or her interaction with anyone that we have not discussed?
Well, I would like to say, we in magistrate court, we are very honored. And so once she felt like I was helping the staff, communicating with the staff, giving the staff direction, she took on more of a hostile type personality or character. I did a training for the judicial staff and she came to the training. We invited elected officials, other departments, so that we can all sit down and talk about how we can better work together. Everybody could understand everybody else's processes. And so she sat there and she said absolutely nothing. She did not participate. It was so bad until I got 2 calls that evening asking, one asked, did we do something to you guys, or did I do something to that young lady? And the other one simply said, whoever that young lady, the tall young lady, she was not happy, she just sat there. I even asked Chief Sanders, Riley now, Miss Riley now, to talk to us about what she has talked about to Jay about what their concerns are, because she is their chief of staff. And she said something so off the wall. She said something like, I'm a religious lady, and so I'm not gonna lie. And so these types of behaviors are observed by the employees. She was upset and then she dropped something that she was eating. She refused to pick it up. And so the staff was like, are you gonna pick that up? So it was going from bad to worse. And the more changes that were implemented, the more upset she got.
What's a TPO?
It's a temporary protective,
And is that a time-sensitive matter?
extremely time sensitive. It's probably one of it, well, it was before, now it's now moved out of the department, but it was one of the most important calendars that we have.
Did you have any issues with Ms. Riley in connection with TPOs?
There was an instance that I had to deal with where one of the employees again reached out to me because there was some high ranking of employees came from the jail, came over and they needed some clarity on a TPO, whether or not to move forward with it. And so one of the employees at the time is Mary. She was trying to explain, they were just trying to come to some kind of solution about was it gonna be served or was it, why it wasn't served. At any rate, there was some issues about if that person lived in the county or not. But at any rate, the employee became very upset because Chief Riley kept interrupting. She didn't have any knowledge of TPOs. She doesn't understand anything about TPOs. And so the information that she was providing was more aggressive. She indicated, why y'all back here? Why y'all talking to my staff? Y'all need to leave. And it really was a delicate situation that needed to be addressed right then. The employees, the lieutenants, the high ranking staff actually went back to the sheriff and talked to them about how they were treated and specifically talked about Ms. Riley's behavior. She didn't at all, was able to give anything substantive on what needed to be done because she didn't understand it. But she was obstructing just a conversation. And then trying to get, so they actually had to convene the meeting, stop. And she didn't know that they ended up talking later in a different area to get it resolved.
Did you ever have occasion to discuss any of these issues with Ms. Riley?
Well, I have tried to do that to something. But she was not my employee initially. So my concern, I took to the chief. And at that time, we had a presiding judge, Judge George. I would take my concerns to her as well. And so I don't know if Judge George had any communication with her, but I certainly made comments. And I mean, she would tell me it's her decision on some things. And it seemed to be more about me. She made a comment that when Judge George was a presiding judge, she didn't make all these changes. Well, Judge George had a different role than the role that I am in right now. And so that was the gist of the problem. And so when the employees would say that makes no sense, we can't do it like that, we shouldn't do it like that. And they would want someone else to know that, and they would come to me, and I would say, you're right. Don't do that. That could get us in trouble, that's not productive, and then they would do it the way it should be done, and then she would get upset about it.
Are there any other performance issues that you experienced that we have not discussed?
I think I can think, if nothing more, I want this town to understand that as Chief Judge Rahil and myself, we value our employees. We have a very family-oriented department. And we like to think that we are very fair, but we do require excellence. And at some point, we had to stop the bleeding. And our employees begged of it. And so we had to do something. And so the something was remove her from that role. We didn't terminate her. We surely could have terminated her. But we tried to use her in a way that maybe without her managing other people, she could thrive a different way. So we tried to create other responsibilities that maybe she could do better at just by herself. She worked alone. And so unfortunately, though the responsibility that she was asked to do, she didn't like those. And so we got a lot of pushback. She was upset, she stopped speaking. It was like a dark cloud over the department when she was there. It was a down. Because she was always just so upset.
To your recollection, were any of those changes to her duties made prior to her FMLA?
Her duties, the duty change was once we removed her. And so, but that, I believe it was prior to that. Yes, it was prior to that, absolutely.
Okay. At any point, either prior to or after FMLA, did she make you aware of any mental health concerns that she had? Or request any accommodation from you or from the department?
I didn't know any mental health illness. She said she was going through a divorce. But we all had problems, and we really tried to be very supportive. I know Judge Rahil would give her time off when she needed it. If she called in and said, "I'm just having a bad day," Chief was more than happy, and many times allow her just to work from home or stay at home to deal with her emotions. I think that her trigger was me. And so the way that she got accepted, me having to give her this role, the next day, or not the next day, but the next week is when she went back in that.
That's all I have at this time. Thank you. Ms. Riley,
Yes,
cross-examine the witness.
Sure. Judge Kate Johnson, when I started working with Magistrate Court,
I can't hear you.
Judge Kate Johnson, when I started working with Magistrate Court, were you aware that I work 5 days a week
You work 5 days a week?
in office?
Yes, yes, I agree with that.
Okay, all right. And also, had other judicial assistants done more than one assignment at the same time, such as Judicial Assistant Rachel Baskin, who was there at the time that I was there, or Mary Mortry?
Your question is, does judicial assistant do more than one task at a time?
At the same time?
Yes, they do.
Okay. Had I assigned either one of those judicial assistants more than one task to do when we were short of help?
I can't necessarily answer that, because, I mean, I wasn't in the makings on every single day. But I can refer to the time. I do know that they would come to me, and they would state that the duty that you were giving them together is not necessarily, you can do, you shouldn't do first appearance with prelim. I mean, it's just impossible. You shouldn't do at the time ex partes and first appearance. And so it's not that they can't do that, they can do more than one task, it's just strategic and it's just what can a JA do or should do? That it just makes sense, it just makes sense, I guess. Based on the role and the responsibilities and what it takes to carry out that job.
Okay. I want to ask you about the incident that occurred on July the 18th. Did I tell you that I was not doing the task, or did I say to you I would handle the matter later?
You did not say that. You did not say that. As a
Okay,
matter of fact, as I testified earlier, initially you didn't say anything. It was after I yelled out to you because I actually thought you, right here, had called you or something. It wasn't until I yelled out to you that you said, you raised your hand like, I'm not doing it. You said, I'm not doing it.
all right. Can you look at exhibit? Exhibit C9.
All right. I have it.
Did you ask me to create a memo or a PowerPoint presentation for the judges because you were doing training?
I asked you to do a memo.
Can you take a look at exhibit A17?
Jack, I have no appellant exhibits.
I don't have 17.
It's A17. It'll be behind the appellate exhibit.
Again, I object, I have no appellant exhibits. I was not provided electronically, and I was advised that she had not submitted any. I don't know when they were submitted, but I don't have them. I object to you.
Oh.
Okay.
I see the backup here.
Mr. Case Johnson.
I think our attorney said he didn't have any exhibits, any appellant exhibits.
Said 817.
817.
Yes, can we get someone from HR? Director Ambles or either Ms. Robinson? Because in my binder, there are appellants exhibits. So we need to
I have them also.
figure this part out.
Board, I'm confirming with Becky to try to get an understanding about the exhibits, because it's my understanding she did not submit a witness list, but she did, submit exhibits, so let me try to.
We have the exhibits. I have.
Okay, so Michelle, you're saying she did not.
You are correct. I do not have them. I did not receive them when they were submitted electronically. I did not receive them when we picked up our package. We picked up exhibits that,
It's in that envelope that I gave you this morning, Michelle.
okay, well, that's in the
It
car.
shows that they may have been submitted on February 13th.
Okay, so are we saying, I need to have a conversation with Ms. Becky so I can get an understanding that pleases the board.
We need to take a break.
Yes, ma'am.
I make a motion, we take a 10-minute break to get this.
Second.
All in favor?
Aye.
Aye. We will be on break for 10 minutes. It's 11:30. Civil Service Board hearing February 28, 2024 will come back to order. It's 11:50 a.m. We're gonna take a early lunch break, be back at 1:30. And we'll continue at that time. Ms. Evans, you missed something.
Will that give you enough time to do what you need?
No, because when I present to the board, I want to present exact, so I have Becky looking for a day.
Okay,
So we'll be ready when we come back.
it's a motion,
Before you go on
I-
break,
Yes.
could I approach?
sure.
Bring something to the shows that I would have. That's what he said.
This is so much.
No. Some questions answered.
All right, with the motion. Board members have a few questions about the exhibit file. For the lunch.
Ms. Ambles, I have a question for you. Just for my clarification, when an appellate submits exhibits, are they required to be brought to HR? Or can they do it electronically?
When there is a submission of the exhibits, Ms. Lancaster, that happens between councils. In this case, it should have happened between Michelle and Shalonda. Michelle would send Shalonda her exhibits and Shalonda would send Michelle hers. I don't think that happened. I think that Shalonda sent her exhibits directly to Human Resources. I believe
Rather
that
than to Michelle?
rather than Michelle. I believe at some point, Becky realized that there had not been an exchange of Shalonda's to Michelle. And Becky said that she thought that she took it upon herself to email the exhibits herself to Michelle, which is something that we don't get into crossfires with the exhibits, but we want to make sure that the process continue as smoothly as we possibly can. So Becky is looking for the email to see, in fact, if she did send the electronic copies to her. Also, Becky indicated that around February 17th, she sent an email to Michelle stating that the hard copies were ready to pick up and nobody picked up the hard copies. So she said she brought them in to Michelle today. Now, I don't like to speak without my ducks in a row to make sure that emails and stuff is in order. So I have Becky and Noy looking through their emails now to be sure that that is in fact the case. But what we do know is that Shalonda did not send her exhibits to Michelle, and that's what she would have been instructed to do.
Okay.
So I'll have more on that.
Can I ask a quick question? You do send out information and instruction as to what needs to be sent to who?
Yes, ma'am, we do.
Okay.
Absolutely.
Thank you.
Absolutely.
I just want to add in response, Becky does normally let me know, like, for example, Mr. Sherritt submitted his exhibits that were not labeled, the electronic ones were not organized in a fashion that I could tell what was what. And she did notify me when he had submitted there was some emails back and forth about what he had to do. And she did notify me when a hard copy of his exhibits were available for pickup, and we did pick those up, and I had them here today. I've checked my emails because Becky normally does, let me know things like that. I'm not saying she didn't send an email. I didn't get it. And I've searched my emails today for Riley, Becky, exhibits. I've gone through my emails. They were due, I think, on the 13th. I've gone through my emails from that time frame. So I'm not saying she didn't send that. And Becky is always, she's very conscientious. She always does things like, so I want to be clear. I'm not trying to put any blame, because she does exactly what Pam says. She really does go sort of above and beyond. But I don't even have, excuse me. I don't have any emails from her about that either, for this one. She did give me an envelope this morning in the parking lot. I pick up things from HR all the time, so she kindly brings them to me if we're gonna be here, today, so that's not uncommon. I didn't open the envelope. I put it in the car, so I'd have one less thing to haul around. So I do have what she gave me, but I just wanted to clarify those things on the record.
And y'all, the board, I hope y'all know that I, as your executive secretary, we try to go above and beyond to make sure that this is a fair process and that when it gets to you all, it flows as freely as possible. But we do send out information telling each side exactly what you need to do and who this needs to go to. And anything we do beyond that is of gone above and beyond, and we don't mind doing that. We'll continue to do that. But I'll let the board know what Becky finds. Thank you all. Thank you, Michelle.
Motion from the board. Adjourn.
Madam Chair, I move that we adjourn for lunch and administrative matters until 1:30.
Second.
All in favor?
Aye.
Aye. So approved. Civil Service Board meeting February 28th, 24, back in session is 1:31 p.m. We left off with Ms. Riley, the appellant, and attempting to question the witness about some exhibits. However, Ms. Youngblood objected to the exhibits. Is that still your position?
It is. I did not receive a copy in advance. As I stated earlier, Ms. Robinson did give me an envelope in the parking lot this morning, but I will submit that the exhibits were not properly tendered and certainly not timely tendered to me. So I object on that basis.
Okay, Ms. Ambles, we left off with you providing some details about that.
And that's why the HR director always like to make sure that she double check herself and my team. Becky said that she did look, she left the hard copies up front like she would have done and evidently got distracted on her way back and did not send the email to Michelle, so you are correct, Michelle. I do want to reiterate what a great job that Becky does, and I think everyone who works with her knows that. I also want to reiterate, and we don't point fingers, we don't put the blame on anyone, that's not HR's position. But the notification letters also clearly states that should be an exchange of exhibits between councils, or in this case, unrepresented appellants.
Thank you.
Mhm.
That being said, with the explanation about the exhibits, unfortunately, Ms. Riley, doesn't appear that you're gonna be able to refer to those exhibits in which, the opposing counsel does not have receipt of. So her objection is sustained.
Okay, let me just say that it would be highly prejudicial against me if any of the evidence that I presented is not used today, because I did submit the information over to HR. And although opposing counsel may have not received an email for pickup, HR did advise that the email about the exhibits, they did advise her about the pickup on the 17th of February. And so if the evidence is not going to be submitted today, then I would like to request a continuance so that opposing counsel can have an opportunity to review it.
Questions?
May I respond? I believe she misstates the information that was provided by Ms. Ambles. Ms. Ambles just clarified that the email regarding pickup was not sent. What she had said before the lunch break was that that was what they believed, but they were double checking to be sure, and having checked that, they've confirmed that I did not receive it because it in fact was not sent, so that misstates the evidence or the information that has been provided to this board. Furthermore, if a case is continued, it doesn't do anything about resetting any of the deadlines, and we are here and we have witnesses sworn in and cases underway, and we would object to the matter being continued.
Madam Chair,
Yes.
it would seem that the appellant was negligent in not forwarding these directly to the county. It was her responsibility. It was not the responsibility of HR to ensure that they were received by the county.
Correct.
Okay, no problem.
Ms. Riley, did you receive your directives to do that?
I did receive a letter in the mail and I read the portion about submitting all of my evidence to HR, and that's what I did. And then I brought the hard copies as well.
You didn't see the information to forward your appellant information to the attorney?
No, I didn't have an email for her.
I mean, did you get written information from HR?
Yes.
Forward, okay. All right.
I'll just say HR communicates by email, so the hearing notice that contained those instructions was sent by email, and if I'm not mistaken, it was one email that went to everyone, so I was copied on that email.
And it's usually the same email because it's something email.
You can proceed, but you can't proceed using your exhibits.
And I would be opposed to a continuance.
Yes.
Okay, no problem. Judge Kate Johnson, did I ever tell you about the tragedy loss of my parents?
Objection relevance. She was terminated in 2023. In her opening statement, she referred to an incident that happened in 2011. And I am nothing but sympathetic to that situation. But that is not relevant to the issue before this board as to the propriety of termination in 2023.
Objection sustained.
Thank you.
Judge Case Johnson, did I mention to you that I was seeking counseling going through my divorce?
I believe that you did.
Okay. Were you aware that I went on FMLA leave on July the 24th?
I don't know the exact date. But that sounds about right. I know our incident happened on July 18th. So somewhere up in there, I would say yes.
Okay. Did I return from FMLA leave on September the 27th?
I believe so.
Okay. And did you and I have a meeting on September the 28th upon our return? Upon my return, I'm sorry. Did you and I have a meeting after I returned from FMLA leave
What day,
on the 28th of September?
what was the meeting about? I have to clarify, I can't.
Did we have a meeting discussing my new duties, my new title
Yes, we had a meeting, yes. absolutely.
on the 28th of September, correct?
It's, once you came back,
Okay, and who was in that meeting with us?
it was myself, you and Judge Bridgewater.
Okay, thank you. And did we discuss making changes to the master calendar? Because we had lost a full-time judge and a part-time judge during my leave?
We talked about the master calendar as that is one of your key points.
Okay, and did you give me until December the 17th to complete the calendar for the entire year?
December,
December the 17th as the due date.
not sure if that's the exact date.
Okay.
Um,
Did I correspond with you via email about the changes to the master calendar and submitting the yearly calendar to you by the due date of December the 17th?
If you had that email, I could have, I'm not sure of the dates, I'm not sure. But there was a conversation about me getting the master calendars out. And the time and matter, and I never did extend that.
Okay, do you remember an email where I correspond with you about when the calendars were due for the entire year?
I don't remember, I'm not that, I want to be clear, I don't remember that. I get 300 emails a day, but I do remember us conversing about the importance of getting that done. And I believe I gave you like a week or either 2 weeks.
Okay. How often in the past, when you were not the presiding judge, but just a full-time judge, did I send out the calendar to judges? Was it quarterly?
And then you would make changes that are necessary or adjustments.
Did I send it out quarterly?
I thought you sent it out yearly.
So you don't remember receiving emails from me
I know
with calendars for 3 months sent out to judges?
What I do know is that you send out calendars consistently because we have so many judges. And there were frequent changes and amendments needed for the calendar. So I know that you did send calendars frequently.
Okay. During that meeting on the 27th, the 28th of September, we discussed extensively about the calendar. Do you remember what else we discussed?
We discussed the calendar, we discussed civil prep. We discussed your duties, basically.
Okay. Do you remember giving me a letter of my new duties and my title?
Yeah.
Okay. And you do remember giving me that letter?
Yes, I remember giving you that letter.
On that letter, did you advise me of new duties that I would perform?
Well, what I advise you, well, prior, these are the duties we were, your duties had changed. So prior to our little incident, your duties were already changed. That's why I was trying to train you on something else, the civil topic, because your responsibilities have been taken on, your supervisory responsibilities have been taken away. And so we were now trying to restructure your position. And when I was trying to train you on that one change, that one additional duty, that is when you walked out. And then the next week you went out without getting delayed. When you came back, we had a conversation. We decided that it would be best to be very clear with you about what your responsibilities are and some additional changes that we have made. But your role has been changed. I would say May. You had come up with your regular chief duties well before that, so it was probably many.
Okay. I would like to refresh your memories, with this letter that you gave me. Is she able to take a look at it and read it into evidence?
Is it the letter that you're saying that I gave you your job?
Yes.
She's one.
No, I object. First of all, she hasn't indicated, she doesn't remember. She testified she does
She did
remember.
say that she did say that she remembered giving me the
Let's try to
letter.
let her, state her objection.
She does not say that she does not recall what happened. She has gone into great detail about what happened at the letter, I mean, at the meeting. She did say she remembered giving her a letter and has discussed what was contained in, there's no recollection that needs to be refreshed. And therefore I object to her showing that document. I particularly object to her reading it into the record, which is what she is asked to do. I object.
Sustain. Objection sustained.
Madam Chair. I did not hear a response from Ms. Riley on the objection by Mrs. Youngblood.
It's fine. You've already ruled on it.
But he didn't hear it. He
said he didn't
couldn't
hear it.
So
She just said it was fine.
maybe the mic needs
just
to
speak
be.
Oh,
Speak
okay.
into the
I
mic.
was speaking to it. I apologize.
Okay,
Okay.
okay.
Judge Kate Johnson, did I report to you directly when I created the liquidated damage flyer?
Yes,
When did you become my supervisor?
I don't know the exact date. It was prior to our incident.
Was it,
Was
it after I returned from
sorry,
FMLA?
no, it's before, it's way before. It was earlier in the year.
Okay. Office coordinator position. Was this particular position approved by the Board of Commissioners?
No, it wasn't approved by the board of commissioners. I don't believe that it had to be approved, but no.
So Clayton County departments can just create positions at will without going through the approval of the Board of Commissioners?
But what we were doing was trying to allow you to keep your job. So what we did was trying to revamp your duties.
So
that
we didn't follow the rules so that I could keep my job?
we changed your job responsibilities. We took away your management position, your management title, your management duties, because the staff could not tolerate your behavior.
Did you
And
all
so-
follow the protocol set
That's
forth?
Riley. Let her answer and then you can.
Okay.
So in response to our employees, we then got with you and said, all right, we can change something. You managing the staff is not gonna work. And so then we decided to place you underneath me, because at that point, I was literally managing the employees. And then, so we just tried to readjust and rearrange and change the responsibilities and see how we could still be helpful to the department.
But you didn't get approval from the Board of Commissioners.
To change your responsibilities, no.
Did you get approval from the Board of Commissioners to create the position?
We didn't create a position. We
Well,
just changed their duties.
you did create a position. You gave me a
So I'm gonna
title.
object. She's, at that point, that's argumentative.
Sustained.
Okay, no further question for Judge Case Johnson.
Is this witness, question to the board,
I have none.
I have some.
Ms. Lancaster?
Yes. Judge, you testified about a huge stack of documents that you found.
Ms. Lancaster, can you pull your microphone down?
I'm sorry. You testified about a huge stack of documents that were found that she had never processed. Can you give me an approximate amount of time that those would have accumulated?
It was brought to my attention by one of the judicial staff, and I'm sure they probably also testified to it, but it was brought to me because if we were looking for the document, I would say a span of 3 to 4 months.
Okay. And you testified that, is it the CP8?
CPU8.
Oh, CPU8.
It's a system that keeps up with that. Inmates and calendars and
And everybody in the office is required to use that system.
everybody.
Would she have received any kind of training on that system?
Well, she actually was instructed by Chief Douglas Hill to sit down with the employees to learn that system. The employee did come back to me personally, and I believe to Chief Douglas Hill, and indicated that she stayed on her phone, she wasn't interested, she would twirl around in her chair, she would make derogatory comments about this was outside of her job description. So, yes, so she did, training was given to her, but she wasn't accepted.
Okay. And she needed to know how to use the system.
She had to know how to.
She had to know, okay. The duty changes, they were made prior to her going on FMLA, is that?
Absolutely.
Okay. And did her new job assignment change her pay at all?
It did not change her pay. We didn't touch her pay. But we were trying to just give her some, because that was a huge piece of her job, the supervision. At that point, she really didn't have a whole lot to do. And so instead of us terminating her, we decided that she could be helpful in some other areas.
Okay.
It didn't require interacting with other people.
Right, okay.
I had a quick question. Did her title change when her responsibilities changed?
Her title did not change.
Okay.
This was more or less, we were trying this out really to see, if it could work. And it did.
Thank you.
You mentioned her title didn't change, but she was chief of staff when she was hired.
She was chief of staff.
Did someone else assume those responsibilities for that position?
Pretty much I did. Judge Raquel and myself took it over.
Okay.
She was not allowed to have any supervision of the employees anymore.
Okay, thank you. You have a question?
Okay,
Okay.
I do.
Yeah.
Okay,
Mr. Smith?
all righty. Judge, what's the hierarchy or the chain of command involving Miss Riley?
You say if she has a problem or if someone else has a problem.
No. I'm asking you, what's the chain of command? Who is her direct report? Who's her supervisor?
Okay, so initially, it was Chief Judge Raquel. And then once she lost her supervisory duties, and then she went under me.
Okay, so the incidents that we're speaking of, or the lack of performance and that kind of thing, who's the direct report then?
She was reporting, when her duties changed, she then started reporting to me, so it was Chief Judge Raquel on top, and then it was myself. And then she reported to me along with the judges, and I assisted with the managing of the employees, the judicial staff.
Okay.
Had a problem, she went directly to Chief Judge Raquel.
Okay. What type of corrective actions were taking for the lack of desired performance?
Well, as I know that I've been in 2 meetings where we sat her down. We communicated to her what the staff was saying. She denied every bit of it. Everything that they said, she disagreed with. And so it's hard trying to get someone to change or consult with them when they're not accepting responsibility. So, in trying to say, well, maybe you should have done this, or maybe you should have done that, she just didn't receive it well. So we try to really, because again, one thing that Chief Judge right here, or nor myself, tolerate is anybody, I don't care who it is, it could be a judge, belittling our staff, disrespecting our staff. It affected the morale in the office. They no longer respected her. So it wasn't that we wanted to do something, we had to do something. And one of the things we had to do was stop the communication. And so, but before that, we sat her down. We tried to talk to her about different situations and maybe you should have handled it this way, or how do you think you could have handled that differently? And so, she didn't receive it well. She was shut down, wouldn't say anything at all. She didn't participate with anything. We were doing any mornings, we do little workouts and get your blood moving. And I would say she at the time, this was Miss Riley. Miss Riley, come on. And she was like, my God, it was just very toxic. And no
Okay.
matter what we said to her, she wasn't received.
Okay. Where's the documentation? Will any of these things documented?
So the big incident between myself and Miss Riley, I immediately, and I believe it's in the evidence, I immediately sat down. I didn't go in the chief office. I sat down, I went behind my desk, went to my computer, and I emailed Chief Judge Hill. I said, as you directed, I attempted to train Chief Riley on the civil trial prep. She walked out without explanation. She nearly knocked an employee over. Doing so, tried to call to see what was going on. She waved her hand in the air. I gave her exactly what happened, blow by blow, or I mean, very, very, very detailed. And then that's when, I'm not sure when they talked, but at that point, I was pretty frustrated because this was becoming a norm. It was issue after issue after issue. And so at that point, I didn't even attempt to talk to her. I just walked away.
Okay. And from your perspective, was any discipline done for that?
Which time do you mean when
What you just described?
Well, I know that, I don't know if there was punishment, but I do know that Judge Raheel spoke with her. And I believe that she got the rest of that week to go home. And then that next week is when she filed FMLA. So
Okay.
it wasn't much time between the incident. The incident occurred on, I believe it's a Tuesday. She was given the rest of that week to go home. And then I believe like that Monday, she went out up in her.
Okay, but you know, paper never goes away. What's written on paper stays no matter when. The incident happened, we document it and it's there from now to doomsday. The incident where you said you found the personal flyers and stuff of that nature on the copier, was
Yes,
that documented?
I provided it to my chief.
But I'm saying any form of disciplinary to the employee, any form of corrective actions to the employee.
No, it wasn't discipline, no, well, I didn't discipline her. I simply, it was the day that she returned from FMLA. It was the very day. And it was stuck in the machine. I took it out and I just handed it to the chief.
Okay. Thank you.
And let me clarify that unfortunately with, especially myself, we have very hectic schedules. And so I would agree that maybe not every minor thing was documented. And we try not to do that. But we do take the time out to consult with them and say, hey, you didn't do this correct, or you failed to do this, or what's going on. And I do know the judge right here did speak to her about, if I'm not sure about welcome to the Board of Fitness. She had just got back from FMLA, and so that may have had something to do with why we just didn't trust her.
But on that, and since you brought that up, but that brings up one thing, obviously, what you guys deal with every day. He said, she said. If there is no documentation of this meeting and what transpired during that meeting, Ms. Riley can say, nope, that's not how it went. And you would say,
You do have
and
that.
you, ma'am, there isn't. And you would say, just what you described, this meeting occurred, I was present, and these things transpired. And she would contradict that and say it did not. And we have evidence to say, yes, it did, or no, it did not. Other than that, it's just he said, she said. And I believe you spoke of 2 meetings, well, at least 2 meetings. I don't know how many before the FMLA or after the FMLA, but we spoke of 2 meetings. And unless there's an exhibit in here that I missed, I didn't see I saw an email, but I didn't see any memo fashion. But that's just me.
All righty, and so the incident that we have been responding to is Exhibit 6. And so it is in writing, and it tells exactly what she did and how to relate the order. I mean, it's literally this.
That's what I'm looking at is an email from Judge Hill to Ms. Riley expressing about her behavior.
And that's the incident that I'm referring to.
But there's nothing about a meeting. You said, was this an incident that you guys met on? And because that's what I'm saying. I saw an email, but you described a meeting, and I see nothing about this meeting, because in that meeting, there's a back and forth. In this email, email is a one-sided kind of thing. I'm gonna send it to you, I'm telling you.
What meeting are you referring to first of all? So I better understand.
That's what I'm asking.
What meeting are you?
Out of those 2 meetings, was any of those meeting covering, can I finish? Was any of those meeting covering this incident where she, as you described, threw her hands up and that kind of thing? Was that meeting describing, talked about the work performance? I believe what I'm gathering, and maybe I'm wrong, but what I'm gathering is the meeting was there addressing her being removed from chief of staff into this office coordinator. Am I okay? Put me on the right track.
Yeah, no, you're not reading that correct. So the incident with myself, this is a write-up with that big incident between myself and Ms.
Hang on a minute. Hang on just a second. You said it's a write-up. What's a write-up?
The email dated July 20th.
Okay, so
It's Exhibit 6.
so you're saying this is a write-up?
Yes.
I mean, I see the subject matter, but an email is a write-up?
Absolutely. Write-up comes in many different forms. Yes, that's a write-up. It doesn't have to say memo. It doesn't have to be. a particular form.
The confirmation of receipt that's at the end.
Okay.
Is that the first part of this or what? Because is it C6? In the beginning, I did not tell Judge Cates Johnson that I would not do the task. I advised her that I would deal with the matter later. I wanted an opportunity to discuss the task with Chief Judge. Nevertheless, your email is received. So this is the, as you call it, the write-up, and this is the response to say I received it.
Yes.
But there's a dispute. But
What is
I
the-
get it now.
What's the dispute? I'm trying to understand your question.
Okay, no, there wasn't a question. I said, I get it. But what I'm saying, in answer to that, to kind of, sort of, she's saying she did not. I did not, and I would not. So it's Henry.
And it's just a lie, it's not true.
I'm sorry, say that again.
It's just a lie, it wasn't, she lied, that wasn't true, I didn't make that up.
Okay, well, I understand what you're saying, but I also hear what she's saying. I'm not saying anyone is lying. That thing that you guys do, we sit and we take this evidence from both sides and we have to determine who's more credible. So I'm not saying anyone lied. I'm saying, can I get enough information to help me make an intelligent answer? That's all I'm saying. And what you're saying is,
I'm insinuating that you were calling anybody a liar, that was me saying that.
yeah.
I'm sorry if I insinuated that.
No.
Saying someone was lying.
Yeah, that's what you said.
Okay.
That's all. I'm repeating your words.
And as the case goes on, you're gonna hear testimony from other employees who witnessed the entire thing. And they're gonna come forward and testify as well.
Okay.
Any more questions?
I have one more.
Yes, ma'am.
Who did her performance appraisal? Did you do it?
No, I wasn't a supervisor at that point. I never did a performance evaluation.
Okay, so,
The
chief
chief judge did.
okay. Were there ever any general counseling forms issued to her about her behavior?
General counseling, the only thing that I did was put in writing the incident that occurred with us. Now, I believe, I'm sure that we had at least 2 to 3 in the office conversations with her. But at that point, we were just trying to change the behavior. So
Okay.
we should have, in fact, written her up, but we didn't.
Okay, so when you had these conversations with her, did you go back and write any kind of memo to the file or anything like that?
I said no.
Okay,
I generally do that for my judges. I'm generally responsible when I see that with the judges.
Any questions? Can this witness be dismissed or held or rebuttal? We're gonna hold her.
Okay.
Accepted.
Next witness.
Shanice Hopeless. I can choose like the restroom.
Oh.
Sorry. Let her take care of what she needs to. While she's out, let me, I will call Haley Miller. We'll call her.
Okay.
She won't be long, and she was not here earlier when the witnesses were sworn in, so she does need to be sworn in.
Brad? You swear the witness in?
Yeah.
Want to come see you.
Could you state your name for the record, please?
Can you speak up, Ms. Miller?
Miller. Where are you employed? What position do you hold? How long have you worked for the Clayton County Magistrate Court?
September 2022.
So did you have occasion to work with Ms. Riley while you were employed at Magistrate Court?
Yeah.
At any point, was she your direct supervisor?
Yeah.
Would you tell the board about your experience in working with Ms. Riley as your supervisor?
My experience wasn't pleasant.
I feel like when she would talk to me, it would be with a little way, if that's the word.
I'm sorry, Miss Miller, they can't hear on this.
I'm sorry, can you hear me?
Yes.
Yes,
I like that.
speak into the mic, please.
Yes, okay. I was saying that my experience wasn't pleasant with her. I feel like when she would talk to me, it would be in a rude way, it would be in a belittling way. When the incident happened with her and Judge Kay Johnson, I happened to be just walking past the office, and when she came out of the Judge Kay Johnson office, she almost knocked me down, and she said, "I'm not doing that." And she just kept walking, and she walked out of the office. And then there was another incident where, at the time I was working just 3 days a week. So I was in the office one morning, because Judge Kay Johnson asked me to come in to work. And I was standing in the office with Marie, Wesley, and another officer or deputy. I think we were trying to figure out what courtroom, our hearing was gonna be held in, I think that morning. So Ms. Riley came in and she saw me and Marie and the deputy, and she looked at me, she said, I said, "Good morning," and she said, "Why are you here?" That was the very first thing she said to me. And I said to her, I said, "Well, Judge Kay Johnson asked me to come in today." And she was like, "Why?" And I said, "Because she wanted me to work, she asked me to come in to help out around the office today." So she walked away and went to go get on the phone, and she walked out to go into her office. So I guess she called Judge Kay Johnson to see about it. There was another incident when I was in the office with her. I think I was in her office talking to her about something that I had did. And she specified to me that if I feel like this job is not a good fit for me, that I can go back to doing DoorDash, what I was doing before I started working the job. And that hurt my feelings. I don't feel like that was her place to say something like that to me, but she did. So, after the two incidents that was personal for me, I really didn't feel comfortable going to her anymore about any issues that I was having. I would go over her and I would go to Judge Wrightfield or Judge Kay Johnson about any issues that I was having, after that. But I just didn't feel comfortable anymore after the two incidents. That was my personal experience.
Did you ever have occasion to go to Ms. Riley as your supervisor to ask her for help with something you were working on or something you had a question about?
No, I will go to a judicial assistant because she simply didn't know. I went to her maybe once or twice, but it didn't go any further with me asking her. I always had to go with somebody
And why did you have to go to someone else?
because she didn't know.
That's all I have at this time.
Ms. Riley?
Yes, Haley, did I hire you? Yes. Why did I hire you? Because it was an open position. Did I tell you that I believed in you, that you could do the position? Yes. Okay. And did I explain to you that we all were fairly new in the office and we were learning the process, so there was a lot of grace to be extended with you learning the job function? I don't recall that. No further questions.
With witness be excused.
Do you have questions?
Oh, I'm sorry. Questions?
No question.
No questions? I have one question. Did you work on CPUA?
Yes,
And how'd you get trained on it?
I got trained by, the judicial assistant, actually, one of our former judicial assistants, Ms. Mary. She trained me a lot, on CPUA, but as well as the other judicial assistants, as well. They trained me as well.
And you relied on CPUA to basically do what for you?
Search cases, put things into CPUA, like, the final disposition on cases, to put things on the calendar, to create calendars, to print things, like, if the case had images, we had to go in there and print the image off.
As well as if someone calls and they have questions, the first thing we do is go to CPUA to look it up.
Thank you. Any witness excused or?
Yes, she can go back to work. Which will make her happy and the chief judge happy,
Any other witnesses?
because now we'll call Shanice's office.
Okay.
Just please be sure you speak loudly into the microphone. Would you state your name for the record, please?
My name is Shanice Hopkins. I'm the principal secretary in the magistrate bench chambers.
How long have you been a principal secretary in the magistrate court?
As a vendor or as a Clinton County employee?
Both.
As a vendor, I came on April 26th of 2023. And as a Clayton County employee, it was July 17th, 2023.
And while you were employed with Clayton County, whether as a vendor or as a direct employee, did you have occasion to work with Ms. Riley?
I did.
Was she your direct supervisor during that time?
Yes, sure.
Tell the board about your experience working with Ms. Riley.
Well, she was my direct supervisor when I came on as a vendor.
Okay.
My very first day, working for that, when I was being trained by Miss Mary Moultrie at CPUA. Ms. Riley came in. I greeted her with a good morning. I didn't get one back. Instead, it was boxes being thrown around. Things in the other office, like the office in front of where I sit, were being slammed on desks. And I looked at Ms. Moultrie and I was like, I don't think she likes me. She's like, well, don't worry about it, because I was ready to quit and just go home. I didn't want to go anymore. She was like, well, don't worry about her. You know, it'll be okay. Let's just keep going. Calls came in, they heard the boxes on the calls, and yeah, that was my very first experience with her on my very first day. That rubbed me the wrong way.
You said that she didn't respond to your greeting and boxes were being thrown around. Who was throwing the boxes around?
Well, it was Chief Sanders at the time, but now Ms. Riley.
Okay. I just want to be clear that you meant that she was the one doing that.
Yes.
Okay. Did you have any other experiences with Miss Riley like that?
I can't remember who I was in the hallway with, but it was like, the hallway right before we, you come out into the main entrance. Someone was in the hallway and I don't know what it was, but she was just like, move, get out of my way, instead of saying, excuse me. It was move, just move out of my way. And then she walked through. The last experience I had, it wasn't an experience with me, but I was coming into the employee entrance. And a deputy wouldn't let Ms. Riley in because she didn't have a badge or anything to prove, you know, to state that she worked there. So as I was walking in, she was like, oh, it's good to see you. I'm glad you came in at the right time because he's not gonna let me in. Will you tell him who I am? I was like, she was like, tell him who I am. I was like, Chief Sanders, Chief Riley? She was like, yes. And she was on her phone at that time trying to show, she was on Clayton County website trying to show him like I work here. And so he was like, okay, well, I mean, ma'am, I couldn't let you in because I didn't know who you were. You didn't have a badge, you didn't have anything. She was like, yeah, but now you know who I am. And she just like walked away. So that was the last instance I have.
Okay. That's all I have at this time.
Any questions for the board? I'm sorry, Ms. Riley.
Shanice, did I put away shipments that came into magistrate court? Shipment as far as boxes of mail, products that we had ordered for the office?
Whatever boxes were in the front, you were the one to open them and put them away.
Okay, and that morning that you saw me putting away boxes, was I putting away a shipment that had come in that morning?
I'm not sure if it was a shipment that came in that morning or not, but I know it was boxes.
Okay, thank you. No further questions.
Now, any questions from the board?
No.
Mr. Smith? Can this witness be excused?
Yes, she can go back to work too.
Next witness.
Rachel Baskin, and she also needs to be sworn in. She was not here this morning.
Mrs. Zimmerman, Ms. Baskin needs to be sworn in.
Got another one?
She'll be the last one.
Swear to bring the information, testimony about it before this court, we don't truth and nothing but the truth, so help you God.
I do.
He's actually, right?
Would you state your name for the record, please?
My name is Rachel Baskin. I'm a judicial assistant to Judge Bridgewater. I've been working for Clayton County since 2016, but I've been working in the magistrate court judges chamber since March 1st, 2021.
And so while you were employed in the magistrate court, did you have occasion to work with Ms. Riley?
Yes,
Was she your direct supervisor at any point?
yes.
Would you tell the board about your experience working with Ms. Riley?
I did not have the best experience working with Ms. Riley. My first interaction with her, she was supposed to sit with me to learn, I believe, preliminary hearings. And from what I observed, she was wrapped up in her blanket and she was on her phone. She didn't really seem to me interested in learning what it was that I was doing and listening to what I had to say about freedoms. I've also witnessed her be rude to members of the sheriff's department. They came over to our office one day to handle a serious TPO matter. And at that time, we were already talking through lunchtime, but at this time lunch had ended. So when they came in, she was shooing them out the door, telling them, don't come talk to my staff. We're talking, but they had direct orders from Sheriff Allen at that time to come over because it was a serious TPO matter that needed to be handled. She wasn't very helpful as a supervisor. If the JAs would foresee an issue, we would come to her and her response would be to go through the problem first and then to let her know at the end of the week how it went instead of being proactive and finding a solution when we brought it to her. She would leave early during the day and when it notified us, so sometimes when the issue came up, we didn't know where she was. I feel like she contributed to drama in the office as well, between myself and another coworker. And at that time, I don't believe I had never had a conversation with her about me making mistakes, but it was an issue where I was off on vacation, and then when I came back, I was met with a write-up for something that was explained to me was something that I didn't do while I was on vacation. And that was my first write-up that I received while working with the county. I feel like she crossed boundaries as a supervisor. She would tell us about her partying on the weekends and her personal issues she was experiencing. And we would have to often go to Judge Kate Johnson for help because we felt that she wasn't helpful.
Just a question on the write-up that you got for things that didn't happen while you were out on leave. Do you remember, was that on a form or was it a memo or was it an email or what was it?
It was I don't remember the layout of it, but it was on a sheet of paper and she did have me sign it.
Okay. That's all I have at this time.
Ms. Riley, any questions?
Yes. Rachel, that write-up, did Chief Judge Keisha Wright Hill sign off on that write-up?
At that time, I believe, I don't remember any signatures being on it at that time.
Did I tell you why I was writing you up?
You did.
Did I tell you that I was advised to write you up by the chief judge or Judge Kate Johnson?
You did.
Okay, thank you. No further questions.
Questions from the board?
She can go back to work.
Excuse.
We're gonna have some staff back in the magistrate court in just a minute.
Next witness.
Okay. Chandra Phillips. Would you state your name for the record, please?
Chandra Phillips.
Where are you employed, Ms. Phillips?
Lane County Manager Report,
What position do you hold?
Executive Assistant and Office Coordinator at this moment.
Is that the only position you've held in magistrate court?
2 years.
When did you start working in magistrate court?
April of 2021.
At any point, did you report to Ms. Riley?
Not really.
So what was her relationship to you work-wise?
We didn't really have a work, my direct supervisor was Judge right here,
And what was your position at that time?
Executive Assistant, Judiciary.
Okay. So you were what we've heard referred to as a JA to Judge Wright Hill?
Her executive JD, yes.
Did you have occasion to interact with Ms. Riley in that capacity?
On occasions, we would interact, we did, Zoom meetings together and we would bring down directives from the top in those meetings together sometimes.
Can you describe the interactions that you had and what you observed from Ms. Riley while you were in magistrate court?
My interactions with Ms. Riley were pleasant. We didn't really interact on a business level or co-worker relationship level. She did her part, and I was directly under Judge Wright Hill, so I worked mostly with her on different things other than what the other judiciary assistants were doing.
At some point, did you take over any duties that previously had been performed by Ms. Riley?
Yes.
What duties were those?
All of the HR meetings, as far as payroll, invoices for our vendors. I took over those duties around like the end of July
Of 2023?
of 2023, yes.
And what did you find when you took over those responsibilities from Ms. Riley?
Well, one of the things I found was we didn't have anything to back up, a backup email or anything to where everything was still going to her email box, everything we couldn't get invoices or any of that information. And we were directed not to call her. And I don't know if that directive came from her. I believe it did, that she couldn't be contacted while she was on FMLA. I learned differently when I went through training that you can't contact someone on FMLA if you need help. And we needed some help. We didn't know how to get to those invoices, so we started from the ground up. And another thing I noticed was for time off requests, they were never being allocated from the full-time staff's allocated hours.
When you say they were not being allocated, you mean
They were not being allocated.
they were not being charged for leave they were
Yeah.
taking? So they were being paid, but their bank, annual leave bank was not being deducted. Is that what you
Yes.
mean?
Yes, ma'am.
Okay. Just wanted to be sure.
Yeah.
I'm clear when you say it's not allocated, what that means. You said that was for all full-time staff.
That was for all full-time staff.
Did that include Ms. Riley?
Yes, that included Ms. Wiley. So if there were any vacation hours, sick leave, or any time taken, it was not taken from the accrued hours that you earn as an employee, a full-time employee. So you could have 300 hours, but could have gone on vacation for weeks, and it would not have been deducted. I didn't see that in the system that had been.
What is CPU 8?
It's like a, like filing system. Everything that's done in magistrate court or the sheriff's office, it's how we communicate with each other. All the court cases that we have, they're all in CPU 8. So if you need information about a TPO or a child abandonment case or anything that they call in for dispossession, we can go into that system and find the court dates or orders, things of that nature.
Now, in your capacity as a JA, we've heard that some other employees had time scheduled with Ms. Riley to sit with them. Did you have any time like that scheduled where she was supposed to sit with you?
Yes.
Did that happen?
I can't remember if that happened. I was so young. I don't remember if she sat with me or not.
Okay. That's all I have at this time.
Ms. Riley.
Chandra, did you fulfill my duties during the time that I was out doing FMLA?
Yes,
Okay, and was that time period from July 24th through September 27th?
From the time you left until the time you returned, yes.
Okay. During that time period, did my performance evaluation come due?
I believe performance evaluations are in September. So
Right.
he would have come back by that time, so I would have stepped away.
Okay. During that time that my performance evaluation came due, who did I report to?
Who did you report directly to? I don't know. I don't know who you reported directly to. And I know that it would have either been Judge Case Johnson or Judge Wright Hill. I was still her judiciary executive assistant. I was not HR, so I wouldn't have been privy to that.
Okay. After I was terminated, did I call you to say, hey, I can't I can't receive any type of assistance as far as my pension because I'm not terminated in the system yet with Magistrate Court?
No, I have not heard from you since.
Did I call you to tell you that?
No,
Okay. Did I call you to tell you that you had to put in my performance evaluation before I could be terminated in the system?
not directly to me, no.
I didn't speak to you and tell you that?
No.
Okay. Do you know when my performance evaluation that was due on September 23rd was entered?
I do not know.
Okay. All right. No further questions.
Questions from the board? Can this witness be excused? Next witness.
Yate Thomas Stanley.
Hi. Michelle.
I'm sorry?
She here this morning?
She was.
Okay.
Yeah, we've covered there were the two witnesses that were not here this morning and they were both sworn. Everybody else was here. Thank you. Would you state your name for the record, please?
My name is Yate Thomas Stanley, and I am the judicial assistant to presiding Judge Latrina Case Johnson with Clayton County Magistrate Court.
How long have you held that position?
Pretty much, I want to say the end of 2022. I was hired on as a vendor. But I've always had the judicial assistant duties. Started out as office assistant, but always had judicial assistant duties.
And during your tenure with the Clayton County Magistrate Court, did you ever report directly to Ms. Riley?
Yes.
Tell the board about your experience working with Ms. Riley.
There were a lot of experiences and, I want to say for the most part, her as my immediate supervisor, it had got to a point to where I just really didn't trust her as my immediate supervisor because I could not get any answers in regards to duties that were assigned to us. When we had meetings, I always felt like I was set up for failure, not to say that she was intentionally setting me up for failing, but could never really learn anything from her. Rudeness, embarrassment, receiving phone calls from other departments, telling me how she would come over and was being very rude. It was quite embarrassing. Always requesting her assistance in training to help me understand how to better to be much more productive as a judicial assistant, and what was required by my judge to perform my tasks. I didn't get those. And there were often times when we had our Zoom meetings where I would ask for help, I would ask for training, I would ask. And just didn't always get it. Was told that she did indicate that she would write down the questions, but never could definitively come back with any answers to help us do the position that we were asked to do in a lot of occasions. So it was just a multitude of things over time.
Were you present on the day that there was the incident between Ms. Riley and Judge Case Johnson?
Yes,
What did you observe on that day?
I observed her actually buzzing out of the door, marching out, indicating that she was not going to do something. I do recall her throwing her hands up, and I remember Haley standing. If she was coming out of the office, she walked on to her left, and Haley was walking up towards that way, so Haley kind of backed up against the wall because her hands had flew up, and she said that she wasn't going to do something. And I immediately looked over into Judge Case Johnson's office with her mouth wide open, like she was shocked at what just happened.
Was there ever an occasion while Ms. Riley was your direct supervisor that she assigned additional duties to you?
Ooh, that was a battle with at the time Chief Sanders. Yes, there was an instance where I was asked to cover, I believe it was Rachel Baskin at the time, I had to do first appearance and preliminary hearings. And I did indicate that that was going to be very, very challenging, but was told when asked to do something, she's asking us to do it because obviously we can do it. I disagreed with her and told her that that's gonna be challenging because of the task that needed to be done for those particular hearings. You know, you had one at 8:30 and then you had one at 11 o'clock. You had to prep for the one that was 11 o'clock, 8:30, you had to be ready to go for a calendar call. To do both hearings were virtual and possible. And I even asked, you know, could you have another judicial assistant do it based on what their rotation was? And just felt like, had she understood what it was that we do during our rotation, because we do have multiple things that we do. But there are some of that's the reason for the way the rotation is set up. Because it all flows together. I felt like her not understanding that, and not knowing what it is that we do, interfered with her understanding how to delegate responsibility to us as judicial assistants. And I ended up leaving late that night. Because again, I'm a team player. I'm gonna do what she asked me to do. And the job had to get done. And I stayed till 8 or 9 o'clock that night to make sure that it didn't get done because I didn't want to let her down. And I wanted to prove that I could do the job. But I did say to her that somebody else should have had the opportunity to take care of that while I took care of the other. But that didn't happen.
Now, at some point, did Ms. Riley cease to be your direct supervisor, your immediate supervisor?
Yes.
Do you recall when that was?
I remember that we received our new judicial assistant rotation. It was like May 19th, around that time. That Madam Chief was sending out, or Chief Judge Rahil was sending out our judicial rotations.
Is that how you became aware that those duties were shifting?
There was a lot of things that were kind of happening where we're starting to notice the change. But at that time, that's when we knew that it was official. that I knew that it was official.
So who did you report to instead of Ms. Riley?
I would, of course, my judge would be, and also Madam Chief.
Is there anything else about your interactions with Ms. Riley that we have not discussed?
I genuinely like her as a person. Genuinely. The fact that we're having to go through this today, you know, it is, it's disheartening, but the truth is that I didn't feel that I would have been able to be successful at what it was that I was doing as her being my immediate supervisor. It took us as judicial assistants to band together because we didn't want to let anyone down, and really, you know, to keep things going, to figure how to do our duties. I just didn't trust her as my immediate supervisor. And again, like I said, it's disheartening. And to have the embarrassment of having to have other departments call you and tell you about her behavior, and them having to exchange words with her based on her being rude and being rude to customers. It's embarrassing because that's a reflection. She's our leader. What does that say about us? Because she supervises us. You have to lead by example. And I didn't get that from.
We've heard testimony about time being scheduled with the other JAs with Ms. Riley for training. Did you have time scheduled for her when she was supposed to sit with you?
I do.
Did that happen?
It did, briefly.
Can you explain that, please?
It was so belittling to know that the reason why she was sitting next to me was to get a better understanding of what it is that I do as a judicial assistant, so that she could better manage and understand what we do and better delegate responsibilities among us. And at the time, Chief Sanders did not want to sit next to me. She moved, she kept being on her phone, she was getting up, leaving, just totally disinterested in what I was doing. Like I was a disease or something. She didn't want to sit next to me and didn't ask me one question. And at one point she was gone. I looked up, she was gone. There was absolutely no turn.
That's all I have at this time.
Yate, when was I scheduled to train with you?
I don't know the exact date.
Neither do I.
Objection.
However, are you related to Judge Kay Johnson?
I'm not understanding what that has to do with me.
Are you related to her, blood related to her?
We're all family.
Yeah. Okay, so did you have an issue with reporting to me because the presiding judge was your cousin?
No, absolutely not. As a matter of fact, if you can recall on Zoom meetings that we had, how many times I've asked you for training, how many times I've asked you for cross training. I came to you, and I came to you in front of everyone else asking you, and I have said to you directly that I didn't trust you when it came to managing you. I came to you, said something to you in the meetings, and if they are recorded, it will show that I have been asking for training.
Okay.
I've never had, on a personal note, an issue with you, ever.
Did you ever receive training that was scheduled by me, set up with the tenured J at the time, which was Mary Moultrie?
Yes, absolutely.
Did we have countless trainings with her?
I didn't have counts. The only time, I don't know if you're referring to when I first got hired, I had training with, Mary Moultrie, I had training with Rachel Baskin, I had training with, Sergina, I had training with Maurice. So I had training and in all honesty, I felt like I needed more training. I asked for more training because I only had training with each person maybe 1 or 2 days. And based on my job description, learning CPUA, learning different policies and procedures, I even asked, could I have more training?
The trainings that you had, did I schedule them?
I'm not understanding.
The trainings that you did have, did I schedule them with the other JAs or tenured associates so that you could get what you needed?
Can you rephrase the question? Like you're asking, well, let me see if I can understand. So you're asking.
Did I schedule the training for you so that someone can train you on different topics?
Yes.
No further questions.
Questions from the board? Mr. Smith, any questions?
Yes. Okay. I'm kind of confused. The training that you said, Miss Riley was sitting next to you, but did not seem like she wanted to be next to you. She was on the phone and this kind of thing and so on and so forth. What was that training?
I believe at the time I was doing first appearance. It was one of the court hearings that we were doing and how we process things within CPUA.
Okay.
Show
So
her what we do.
I'm sorry, say that again.
To show her what we do.
Okay, so you were conducting the training to her.
Correct.
Okay.
All of us was assigned to do that.
Okay. And asking her for training, what type of training were you asking for and what type cross training were you asking for?
Oh, man. Different departmental training. One thing about magistrate court is everything starts with us. So everything that we do goes to different departments. In the beginning, not understanding time restraints on getting documents in, what the other departments were looking for in regards to getting orders processed, just more departmental things. For example, with the clerk's office, understanding once first appearance is done, certain documents had to go to maybe for let's say the public defender's office. The CAA forms or court appointed counsel forms had to go to that department. The clerk's office only needed the warrants or all the documents to understand where everything goes and their time constraints. Because sometimes if you get something in too late, somebody needs to find out because the paperwork didn't get in time. So I wanted training from other departments to understand what their processes was. Also, for example, recalls. There was one of the job descriptions that was on our rotation for doing recalls, man. We constantly, and well, let me speak for myself. I constantly asked for training for recalls. And I do recall one time that she did have Miss Mary speak to us about the processes, but there were questions that were posed that came about regarding what that process was based on another department. And we posed that question to, at the time, Chief Sanders, and could never get an answer for it. To process these recalls, because there were so many different dynamics on getting one thing processed, one order processed. So those were different things that we were asking that we just couldn't get in the echelons, what was asking for additional training.
Okay. And when this was going on, about when was this? Just a ballpark, month and year?
In the middle of the year. Around the
So
middle.
June, July?
I really didn't pay attention to date and times of everything that was going on, but I know it was in earlier part of the year. I couldn't just give you a definite whether or not it was June or July.
What year? What year?
2023, my apologies.
Okay. And you came to that position when?
At the end of, it was in November of 2022, between November and December, I don't even remember exactly.
Okay. And that's it. Thank you.
Ms. Whitney be excused.
She can.
Thank you.
Can we take
Any more witnesses?
We do. Can we take a quick bathroom break before this?
Sure, I'll make a move, we take a quick break.
Second.
All in favor?
Aye.
Thank you. Break for 10 minutes.
next. Yeah, go first.
Okay, make it three.
You go first.
February 28, 2024, back in session is 2:58 PM.
Ms. Lancaster, can I get a time check?
Sure, you have 36 minutes and 3 seconds, and Ms. Riley, you have an hour and 7 minutes.
Thank you. We call Chief Judge Keisha Wright Hill. Would you state your name for the record, please?
Keisha Wright Hill, Chief Magistrate Judge, Clay County,
And how long have you been the Chief Magistrate Judge?
since January 1st, 2021.
In your capacity as Chief Judge, what was your working relationship with Ms. Riley?
When Ms. Riley, initially came in as Chief of Staff, she was to supervise, it's almost like a triangle, she was to supervise the administrative staff. Judge Kate Johnson was to supervise the judicial staff, and then I was over everybody.
Did you hire Ms. Riley?
I did,
What position did you hire her for?
Chief of Staff,
At the time of her termination, what position did she occupy?
Office Coordinator.
Now, was that her civil service position, or was that, those were some of the duties she was performing?
The duties changed to Office Coordinator, but she was still in the position of Chief of Staff.
Direct your attention, if you would, to Exhibit 12.
Yes.
Can you tell us what that is?
This is the description of Chief of Staff for me.
That was the job you hired her, excuse me, to perform. Okay. Now, at some point, her duties changed. Is that right?
That's correct.
Do you recall when that was?
I believe, around May of 2023.
And why did her duties change in May?
So what happened, generally, the admin team would have a weekly, meeting, usually on Fridays, just to see what was going on, change meetings made, their weekly meetings. And those meetings would be with the Chief of Staff. Sometimes I will pop in and out just to see how everything was going. This one particular meeting, the JAs had asked if they could speak with me alone. And so, sometimes we did them on Zoom, sometimes we did them in person, if everyone wasn't in the office. But on this particular day, the majority of, JAs were in the office. So I said, yes, we can talk, have an open door policy. And so we went into the conference room and they just began to pour out a multitude of issues that had come up. Things had came up before, but this was just overwhelming. It wasn't just one person saying it, it wasn't just two people saying it, it was multiple. And I believe and I can say that since I've been in my position, I think I probably extended more grace, patience, beyond second, third, fourth, fifth year. I've done that all to Ms. Riley. I've given her more chances than anybody that has been in my administration. And so when I'm hearing from my staff that the chief of staff, the person who's supposed to be supervising them, is supposed to be uplifting them, encouraging them, training them, ensuring that, you know, answering their questions, all of this, that person, their go-to person is belittling them and demeaning them, talking to them like they are children, saying, you do it because I said to, not because it's right, not because it's the law, you do what I tell you to do. That's disheartening because I tell my staff that everything that you do, you're representing yourself, you're representing Magistrate Court, you're representing me as the chief, you're representing Clayton County. And so we have to, you know, exhibit exemplary customer service with departments, in between departments, with the public, with one another. And so to hear just a multitude of situations, I had to do something. And again, this wasn't the first time I heard it, but it was just overwhelming. I had to make a change, and at that point in time, I said, if this is what's taking place, because you can smile in my face, but do something else behind my back to my staff, and it should not be. And so, if this is the situation, I do exit interviews with people that leave. And so I've already had, there was at least 3 people that said, I'm not gonna say that they said it was the only reason they left. But some people leave, you know, for higher pay or, you know, we want to further their education or whatever. But I can say that there were 3 employees that left Magistrate Court. And it stated specifically that one of the reasons is because of Chief Sanders. So I'm hearing all this and I had to take action. And so I didn't terminate her. I said, because I understood, you know, she had personal situations going on, personal issues. I know that she was going through divorce, and I understand. So I wasn't trying to kick her out and end her employment. I was trying to be accommodating. So that's when I said, well, as far as supervising staff, that's not in the best interest. Because in a minute, everybody's gonna be. It can't be everybody. So I had to make a change, and what I did was, I said, well, I'm gonna remove the duties of you supervising over the administrative staff and, you know, handle other duties in the office. Other duties that still fell under chief of staff. Her pay did not change, and she did for a long time was still being called chief of staff. The staff kept saying, you have to keep calling her chief of staff because she's not over the staff. But I said, you know, as a matter, yes, because I'm thinking maybe maybe there'll be a change. Maybe something will happen, but it didn't. It didn't improve. Things just got worse.
Now, the issues that the staff raised with you at that time, were they matters that you had previously discussed with Ms. Riley?
Yes, so I would meet with Chief Riley, I would meet with Ms. Riley, I would meet with Judge K. Johnson multiple times a week, but I mean, on a weekly basis, we would meet. if there's an issue that came up, I would pull it in and address it. Oftentimes with Judge K. Johnson, I rarely meet with anyone alone. Unless it's just something, personal. But if it, I would oftentimes bring in Judge K. Johnson just to address the issue. This is what the staff is saying that they need, or this was brought up, they should do it, or this wasn't done. And to try to rectify the situation, bring it to her attention, hope that there will be some type of change.
So some of the meetings were regular, ongoing, weekly administrative meetings. Excuse me, is that right?
We met multiple times during the week, yes.
But some of them were in the vein of verbal counseling or coaching designed to modify her behavior. Is that
Correct.
okay? Now, at some point, did you address any of her performance issues in writing?
When the situation came up with Judge Kate Johnson, when that issue came up, I did, the email that I sent out, I did send it out to be a write-up. It was just, to me, it was just clear insubordination, and I asked her about that. And, and she said, well, I wasn't saying that I wasn't going to do it. I just said that I wanted to check with you. When my second in command, who is giving a directive for me, is asking me to do something, and clearly I sanctioned it. And so to just blow her off, that's insubordination. If I'm telling you to do it, and if Judge Kate Johnson is asking you to do something, it's just like I'm asking you. She's my second in command.
Did you receive corroboration from any other employees in the office about what transpired in that incident with Judge Kate Johnson?
Yes, because they all were there. We have a walkway. All of their desks are right in line. So the judges' offices are on one side and the corresponding assistant on the other side. So all of them are right next to each other. So when this is happening, and I wasn't there, but when it took place, all of them were at their, respective desks. Everyone saw and heard what took place.
And did the information you received from the other employees match the accounting you received from Judge Kate Johnson?
It did.
Direct your attention to Exhibit 6, please. And can you tell us, specifically start on page 2 of Exhibit 6. Okay, and tell us what that is, please.
So this is the email that I sent that serves as a write-up for our purposes to Ms. Riley as to what took place in that on July 18th. And I asked her to, confirm receipt, to confirm that she got it. And, she blew it off the way she has done, not accepting responsibility. There's one thing to say, I didn't do something. There's another thing to say, you know what? I apologize for my actions and my behavior. I was out of pocket, or I was having a bad day. But that doesn't take. One thing Ms. Riley would not do would be to accept responsibility. Like when you're right, you're right. When you're wrong, you're wrong. So if you've done something wrong, the first thing is to acknowledge it and then try to correct it. Apologize to people that you hurt, whether knowingly or unknowingly, intentionally or unintentionally, and try to change your behavior and with a change in action. But if you're not even acknowledging what you've done wrong, how does that serve as any type of example to the people that you supervise?
So on the first page of Exhibit 6, that email at the bottom, is that what you received in response from Ms. Riley?
Correct. That was her reply.
What did you do when you received that?
what did I do when I received her, reply?
Right. Did you have a
Oh,
conversation with her
yeah,
about it?
So. Well, actually, let's go back because. When she sent the reply, she was out. So. Let me say this, Ms. Riley said earlier and tried to make it as though. Her change in duties was retaliatory because she went on FMLA, and that is not correct. Because changes were taking place, I know that I started taking over the administrative calendar that I sent out to the administrative staff as far as their duties in May. Not in September, in May. So when this incident took place with Judge Kate Johnson on the 18th, I called her in and I spoke to her about it. And I said it was unacceptable. Again, she immediately turned and tried to change the scenario. And then she started getting all upset. This is in my office. Now I'm having a normal conversation. I'm saying, she rather, it's been brought to my attention that this took place. She just gets all upset, starts crying. She just was just really out of pocket to the point where I said, you know what? Maybe you just need to take the day. Let's just, because I'm not trying to upset you and have you all upset or what have you. It was like she was very defensive. And got very upset in that meeting. So, and I told her to take the day, but she was so upset that I said, as a matter of fact, why don't you just take a week? Just whatever you got going on, maybe it can be rectified. Let's just try and start this over anew on Monday. So, but then she went out on leave. So when I said this, she was already out. You understand what I'm saying? This took place on the 18th. But it was just it was too much. So that's why I was like, I sent it on the 20th. When she responded, that's when she came back and said, I am going out.
Okay, so I want to be clear, at the time you sent the write-up on July 20th, you had sent her home, but she was not out on FMLA at that time.
I believe so.
Okay.
Because she was supposed to come back on the 24th, which I believe is a Monday. And that same day was the day that the day that she was supposed to come back was the day I believe that I got the notification that she went out.
Okay. After she returned, did you have any other discussions with her about her performance? Did anything change after she came back?
Well, I think, and that's when I think the meeting took place with Judge Kate Johnson and Judge Bridgewater, because I was not, I don't think I was on site of the courthouse. Just to reiterate, her change in duties, that was not the first time that it came up. So I think that was kind of referenced as though when she met with Judge Kate Johnson, that, oh, I came back from FMLA and all my duties have changed. No. That had taken place that in May, when I started doing the calendar. It was just, okay, you're back, because she'd been gone for so long, she'd been gone from July to September. So it was kind of a meeting like, you're back, okay, so let's just refresh your memory of what it is that you're to do. And this is what here it is laid out. I just want to make that clear. It didn't go into effect. It was just reiterating because she'd been gone for.
Okay. Shifting gears for just a minute, when an employee is hired in the magistrate court, do they go through Clayton County's orientation?
Yeah.
Direct your attention to Exhibit 11, please. Can you tell us what that is?
The Clayton County Board of Commissioners new employee orientation form.
Do you recognize the signature at the bottom?
Yes, that's Ms. Riley. It was Shalon Sanders at the time.
Okay, I was gonna say, we've heard some references earlier about a name change that took place.
Right.
So she was Sanders when she was,
Changed the right.
okay,
So she
right.
came in Shalon Sanders and then she got.
Okay, so this is Ms. Riley's form.
Correct.
Okay. Once you made the decision, well, tell the board about your decision-making process in arriving at the decision to terminate.
I'm sorry, didn't hear you.
I said, tell the board about your decision-making process in arriving at the decision to terminate.
So it had just escalated, so much had taken place. I had spoke to her on numerous occasions. Tried to bring to her attention issues that were affecting the court, affecting the staff. Whether it been how she talks to adults or how she represents the court with other departments or her work product, as far as what's requested of her from either, you know, from myself or Judge Case Johnson. I had tried that. Then I tried to change the duties. Okay, let's see, what can we do? Another alternative. So let's take away, since she has an issue with talking to the staff, and it's a problem with her supervising them without being demeaning or belittling. Okay, let me try to separate and move that task away, but there are still other tasks that have to be done. Mastering, you know, the calendars and there are still other tasks that need to be done. So I just removed that task, but there's still other tasks. And to try to justify, okay, she's in the state that paid the same. In order to justify taking away a task, I brought in another task. Okay, let's let her help with the civil prep with the judge. She can't supervise the admin staff. Let me have her help us prep the files for the judges. Again, an alternative to just, she can't be here. And then when I do that and ask Judge Kate Johnson to train her and show her what it is that she will be doing with her new task, now it's an act of subordination. So it's like I've done multiple things to try to keep Ms. Riley here. It's not, but her conduct and her behavior and her insubordination, her disrespect, her poor, you know, product of work, that's why ultimately I didn't have a choice.
At any point during your discussions with Ms. Riley, did you advise her that failing to modify her behavior would jeopardize her job?
Yes.
Do you recall how many times?
No, I don't. We met numerous times.
Was it more than once?
Yes.
Now, at the time that you made the decision to terminate, or were considering the decision to terminate, did you consult with anyone else?
I did. I contacted HR, Ms. Ambrose on 2 different occasions.
And what was the outcome of that consultation?
After I spoke with her and let her know the situation, she did not have any concerns as far as me moving forward with term.
And did she give you any guidance about how to move forward with termination?
She did. That's as far as the notice of termination, as far as giving her an opportunity to respond, you know, waiting 72 hours or what have you, 3 days before it actually went into effect. I didn't know all that. I got all that from Ms. Andrews.
Direct your attention to Exhibit 3, please. Can you tell us what that is?
That's the notice of termination.
I think we've discussed most of these issues. We've discussed the personality conflict. the managerial performance, the insubordination. If you look down at number 6, critical time sensitive tasks not performed in a timely manner. Tell us about the bond hearings that were not scheduled.
So one of the tasks of the chief of staff was to delegate motions that need to be scheduled for the hearings. And so one of those motions that we get often are bond hearings. This is people are sitting in jail requesting a hearing for bonds they can get out. I have never been incarcerated, thank God. But I always put myself in other people's situations. I don't want anyone sitting in jail any longer than they are supposed to or need to. And so when the mail comes in, she's supposed to go through, see that there are 3, 4 bond motions for bond, and give that or delegate that to a judicial assistant. So that they can go in the CPUA and do what they do and schedule it so it can be put on here. And so while she was out, we find multiple motions for bond in the office, the city. So when, we're like, trying to figure out, attorneys are calling, well, I filed this motion, or I sent this motion, what's the status? They're like, we don't see it, or, we're trying to rectify the situation, because they're sitting in the office, that's time sensitive.
Look, if you would, at exhibit C4. Can you tell us what that is?
I believe this is the, with the civil service.
So looking specifically, beginning at the bottom of first page, 9.206.
Causes for dismissal.
Can you identify for the board which sections you found for conduct violated?
So it's 9.206. Well, we haven't even got into G, but there's other things that took place, that's classification on duty or off, free and reproach upon the county. I didn't even try to go into that in my notice of termination, but there have been multiple instances of that. But beyond G, I, guilty of actions which amount to insubordination or disgraceful conduct, whether committed on duty or off duty. K, incompetent, negligent, or inefficient performance of duties of the position held. I believe I don't know which, if it's. I know one of these had something to do with, county property. I don't know which one that is. But I know the day that the last day that she was there. Her, Ms. Ambles, I had contacted the sheriff's office for her escort. And I told her, that she was being terminated. And the deputies were there to walk her out. And I kind of stepped away and gave her some time to gather her things. And I kept going back in, and it was like taking forever. Like, she wasn't packing up anything. She was just scrolling on her phone. I was like, I would go and I was trying to give her privacy, respect the privacy, and I would go and leave like 10 or 15 minutes, and she's still on the phone. I'm like, are you ready? And she's like, I have to delete all of my personal pictures. Now, this is out of the county phone. So I thought county property is supposed to be for county business. That's number one. So I don't know where that's at about as far as, county property. But I do want to say something that, was disturbing to me. And it's on the same day. So after she was escorted out to the parking lot, there was another former employee, Miss Mary, who y'all heard. I think everybody said she was kind of the matriarch in our court, but she works in the juvenile program. And she saw, Miss Riley. Miss Riley said, yells at her across the parking lot, "These MFers done F up now. I got something for them." I didn't know how to take that. It bothered me and disturbed me and it kind of scared me. I let the sheriff's office know. They put a bolo out, like she didn't even come back into the courthouse, at least for that day. And so that, and now I'm hearing, because this is the first time I'm hearing about mental illness that she stated, it's concerning to me. And then her instability.
Judge Wright Hill, as you sit here today, do you still believe termination was appropriate in this instance?
Absolutely.
That's all I have this time.
Madam Chief, do you remember when I filled out the FMLA paperwork that was submitted to HR? Did you get a copy of it?
I got a copy of it, yes.
Do you remember getting an email stating that my FMLA was approved?
I did.
When the FMLA was approved, what was my job title?
Keep it back.
Can you turn to Exhibit C7?
Yeah,
What was the date that I was hired?
September 4th, 2021.
Is a performance evaluation due each year after the hire date?
Yeah,
Was a performance evaluation done for September 2022?
no.
2020,
It's still out, I believe. Nothing wrong.
okay. Was a performance evaluation due on September 2020, September 4th, 2023?
I don't know when.
I'm sorry,
I don't know.
you don't know if it was due,
I don't know when it would be due.
but you do know that a performance evaluation is due each year on the anniversary date of hire.
Okay,
Is that correct?
okay.
Okay. Judge Kate Johnson testified earlier that she did not do my performance evaluation because I didn't report to her then, that I reported to you. During the time that my performance evaluation came due on September the 4th, 2023, I still reported to you, right?
That's correct.
Okay. And then when I returned on September 27th, I started to report to Judge Case Johnson. Is that correct?
Correct.
Do you remember doing a group meet, which is our mobile app for the staff to communicate? That I was not an office coordinator for Magistrate Court?
Yeah,
Okay. Do you also remember changing my email title from Chief of Staff to Office Coordinator?
yes. And let me be clear and reiterate, your pay did not change. That was more internal because you were no longer over the staff. You were chief, not chief of staff. So it makes no sense. So I was trying to make your title fit the duties that you were still holding.
Okay.
But your pay did not change.
Did you have this new position approved by the Board of Commissioners?
I spoke with Ms. Ambles, and she said that I could change duties.
Is that the
Duties
norm?
are-
Is
She's
that the-
director of HR.
Is that the normal process for adding additional positions to a department?
I didn't add positions, I changed the name. Because we didn't make the staff was asking, she's not over the staff. I did not change. You still were doing duties that were under chief of staff, so for all intents and purposes, the duties did not change other than you not supervising the staff.
But there was a change in who I reported to, is that correct?
Yes,
Okay. And that occurred after I returned from FMLA leave, correct?
I'm trying to. I'm trying to remember now if you were reporting to me or reporting to Jeff Johnson.
Did
I
you,
don't recall.
did you ever write me up or coach me in my current position as chief of staff to improve my performance if it had fallen?
I gave verbal coaching to you on numerous occasions when I met with you in my office, and you were well aware.
Did you ever do a written improvement plan?
I wrote you up, as a result of the July 18th.
But did you ever do an improvement plan for me to correct any issues that you had with me prior to that incident?
I told you about it on numerous occasions.
But did you,
And you know what? In retrospect, if I would have wrote down every time you did something that was out of line or inappropriate or inadequate, I would have went through a ream of paper.
and we wouldn't be here today?
Objection. Argumentative.
Stay.
Did, under my new position as office coordinator, I received, I was under that particular position for 5 weeks. During that time, did Judge Case Johnson ever write me up for anything that I did wrong under that particular position?
The position was the same. I changed the title and took away your supervisory duties. So let's not make it as though I created some type of position. It's all of the same duties that you were supposed to be doing as chief of staff, minus supervising the administrative staff.
But did you
not
get
change-
approval from the
I
board?
did not check. It was all the same duties. I did not make up a new title, make up a new position. I did not make up new duties. If you look at all of the duties that you were to perform under chief of staff, I just took away your supervising the administrative staff due to your inability to talk to them with respect.
Okay, Judge Case Johnson testified earlier that I did have new tasks. Do you remember that I had new tasks added?
Well, actually, it's not new tasks. If you look under, what is the exhibit for,
C12.
Well,
yes, I did not create any duties. So if you look under the duties under chief of staff, if you look under, midsection, prepares folders, researches files as requested. That's the same thing. We were just having you do it as part of being specified as doing it for civil cases. And if you look under essential functions, other duties may be required and assigned. I did not make up a new position for you. What we did was spell out specifically which we needed you to do, but they fell under chief of staff.
Did I perform poorly up under the title of office coordinator?
Yes.
Was I given any type of coaching or improvement plan so that I could rectify the situation?
For many, many months. were given numerous opportunities.
Was anything written so that I can
I've already
improve?
answered that.
Was anything written so that I can improve under my new title? Was I given time to improve and get my performance up to par? After I returned from FMLA?
I've already stated what I put in writing. I did verbal coaching.
Okay, no further questions.
I have a question. Judge, what I'm hearing is that in your office, you communicated verbally and utilizing emails rather than utilizing the forms that were provided by HR for general counseling, et cetera. Is that the normal practice in your offices?
Well, no, this was the first time that this situation came up because generally the chief of staff is the one that handles all of the write-ups or what have you. So I've never, that generally was the chief of staff.
Okay, the first foray into this, dealing with the individual at this level.
Correct, because normally the Judge Page, the presiding judge handles all of the judges. The chief of staff handles all of the admins, office assistants, secretaries, judicial assistants. They handle all of that. And they report to me. So this, I've never had a position where I've had to write up. Normally the chief of staff.
And so the change of duties and responsibility, more or less, was your way of doing like professional performance development plan.
Correct.
Okay. All right. Thank you.
Okay, I have a question. Judge, you testified about having, a meeting with all the JAs.
Yes.
Can you tell me about what time period that took place?
It was like May.
So it was before she went out on FMLA?
It was, and the reason I know that is because I think I took sent out, I started taking over, so in addition to everything that I have to do, I started taking over the duties as far as them reporting directly to me after I had this meeting. So when was, something came up where someone was sick or I'm gonna be late or whatever in their duties, instead of them going to Ms. Riley, they would come to me. Well, I know that I sent out the weekly rotation as far as what JA is on this task, what JA is on that task. I sent that out in May. I wouldn't have done that if she was doing it. So that's why the first one I sent out was around May 19th. That was after that meeting.
So you had to take over that task?
Right.
I don't have any other questions right now.
Mr. Smith, you have any questions?
Yes, I do. Judge, was there any type investigation done on any of the things that you say Ms. Riley was doing that weren't kosher, to put it nicely?
Were there any investigations, you said?
Yes, ma'am. Anyone, of course, you spoke with Judge Johnson about the incident with the hand throwing and that kind of thing and some other folks, but did they memorialize any of these things in a memo to you all to say this is exactly what occurred on this day?
No, I did
Okay.
speak to those deputies, those sheriff deputies about the incident with Miss Mary and the TPO. They were highly upset, and because I wanted to hear what they said. I'm always going to listen to both sides, and they were very upset, and so I did talk to the.
But we didn't memorialize any of that.
No.
Okay. And on the termination, on the day of, okay, you served her with a notice of termination, correct? Okay, and the day of termination, was there a hearing held? Or what transpired? Or did the service of that notice, that just was the beginning and the end?
I'm correct. I met with her and, gave her that notice. And it, as I was instructed by, Ms. Ambles, I had at the bottom that she had until November tenth. She wanted to submit a rebuttal. She did not. And so I got that language directly from the state.
Okay, so when she didn't submit a rebuttal, nothing else was done? Is that, or did she come in and you officially said, hey, you're fired?
Correct, but because Ms. Ambles advised me that she, when I do it, that she needs to leave the premises that day.
Okay, let me ask you this. In your tenure, have you or any of your, I guess, senior staff or whichever way you, those folks that are in charge of other folks, have they attended any training on the way Clayton County operates as far as it relates to civil service, as far as it relates to discipline that is put on by HR?
That would, if so, would have been Ms. Riley as chief of staff.
Okay, so you were relying upon your chief of staff to negotiate all this stuff, and you were just gonna follow that lead.
Correct.
Is that okay? And today, when you looked at, well, hang on, since I got this one pulled open up in front of me, exhibit C7, that's a performance evaluation. And I believe you completed that one yourself. And I'm looking at the date that it was signed, so I'm gonna say December 28th, 2023.
Yeah.
Okay. And the scoring was a 16, is that correct?
Yes.
16 is well below any acceptable in my tenure from working and that kind of thing and so on and so forth. 16 was something that if you were going to hang on to them, that may have been a biannual at that 6-month part, but you're going to have to get up above a 16 in order to be a tenured employee. And we're talking about someone that's had been in, I don't know, that position for at least 2 years, and it's a 16. Why are we retaining that person?
I don't understand the question.
This evaluation, let me put it in a layman's term. This, I'm sorry.
That was submitted at the end of 2023.
Yes, December 28th, 2023.
Right.
And I'm looking at date assigned to position was September 4th, 2021. So I'm assuming from this evaluation, this person has been in this position for 2 years.
Correct.
And this person in a position for 2 years is scoring a 16. And my question is, why did you retain this person if they are well below average?
I terminated her on November the 7th. I submitted this because HR came back and told me that it needed to be submitted and,
I got you. Okay. When Miss Riley was committing these offenses and so on and so forth, I believe someone asked, I don't remember who, about a written plan, a plan of action in order to better the performance. You know, when you have an employee that's subpar, it's incumbent upon the supervision to coach, to train, to show where I am trying to save that employee. And I get a part of that saving from you, and I said that was a whole lot. That was truly grace and mercy. Was changing a little bit of her duties and took that staff responsibility out and just said, hey, just do what you're supposed to do. Don't interact with staff. So was that memorial?
I didn't say don't interact. I didn't want her to supervise. I wasn't ousting her from the court. I wasn't putting her in the corner and saying, no one can talk to you, you can't talk to them. I wasn't doing that. It wasn't her inaction. It was her being in a position to supervise.
Okay, I'm clear. That just poor choice of words on my part. So was that kind of sort of your plan of action to save the employee?
Yes.
Okay. And truly, to as I know it, under civil service, for an employee to be disciplined, we have to tell that employee what rule violation they broke. What offense did you commit? I didn't see any of that until, well, I still didn't see it. I heard it today, being prompted by Ms. Youngblood to cover the rule violations. So what I'm trying to get right in my brain, so help me out. When you made the decision to terminate Ms. Riley, you listed these incidents that occurred. I can glean from it rules and regs that were broken as far as civil service is concerned, but it does not tell me that. It's not memorialized on that. And that's just what I see as an employee. That's why I was asking about, did you meet with her, or was it just, I got the notice and I read it and I'm supposed to understand what transpired?
No, I met with her on multiple occasions and.
No, ma'am, I'm saying at the termination, for termination.
And numerous occasions before the termination, I said, this is, a change has to take place. Clearly, if I took those, the duties of supervision away in May, I've already said, and you've heard testimony from other people, I give second, third, fourth, fifth, 10, 15, 20 chances. I spoke to Ms. Riley on numerous occasions. If I took away the duties in May, it didn't just happen in May. This is a culmination of issues that have not been resolved. I didn't say, oh, someone said you talked to them wrong in May, you're not chief of staff anymore. As a matter of fact, I made them continue to call her chief of staff, even though I took the duties away. They said, if we start to call chief of staff, I was, yes. Because I'm thinking maybe something's gonna change. So I say all that to say, when you look at the big picture here, I didn't just start discipline, verbal coaching, meeting in May. I didn't just decide in November, I'm gonna terminate her. Ms. Riley knows that she had multiple meetings with me, had multiple opportunities to get it right. And she just chose not to.
Okay.
I have a follow-up question to that. What you said about multiple times of meeting with her, coaching with her, about, in your estimation, about how long of a period were all these coaching sessions and meetings, did that occur? I know and you didn't say it just didn't happen in May. So going back, how far back were you doing?
Well, I'll say this, September. Was her anniversary month. And so while I did her first performance evaluation September 2022.
Which would have been the end of her probationary period, right?
Yes,
Was she operating or performing at an acceptable level then?
yes. So that was September 2022.
So
And then,
between that time and May, it just went downhill, right?
yeah, and like I said, I know I was aware, but I remember doing her evaluation. I mean, it wasn't, perfect. Nobody gets a perfect, but it was definitely much better than this. And so I knew that she had, was going through divorce. I knew, that's why I'm not trying to kick somebody when they're down. That's what I'm saying. I'm trying to get every opportunity that I can to try to help you in the situation, whatever the issue is. Even when she was going through divorce, I would have been more accommodating, I think, than anybody. I let her, take time to meet, to prepare for a divorce. She went out had the divorce hearing. She took time after that to get herself together. I let her work from home. I have been more than accommodating. I have spoke with her on multiple occasions, so I'll say, I don't know when it started from there, but I know September 2022, when she had her year, it wasn't perfect, but it wasn't nowhere near where the second was at. So I don't know how much of her personal situations, well, obviously it impacted it tremendously. But I still was trying to assist her, trying to help her, trying to support her, trying to make accommodations. I reached out to UHR, said, I'm not trying to mess with her, what can I do? Ms. Emma said, well, you do have the ability to change, to move or change her duties. That's what I did. Based on everything that took place, this is not something that just happened overnight. Is what I'm saying. And then it's not like I just talked to her one time or two times. I talked to her multiple times on a weekly basis. Anytime something happens, and my staff will tell you, I'm gonna, address it, talk to them, okay, this is what happened, this person told me this, or this took place, this didn't happen, this didn't happen. What happened? What's going on? How can we fix it? How can we rectify the situation so it doesn't happen again? You got it? I got it, we good? Let's go back out. I talked to her on multiple occasions. This is not like, oh, I came to work and I got fired. No.
During her probationary time, from the time she was hired on until the end of that first year, that September, what was her behavior and her performance like then?
I think I'm a very generous boss. The fact that if you don't know CPUA and you gotta use CPUA to get it, even if you're on the phones, they're gonna call, when's my court date? You gotta log into CPUA. Do I have it here? You gotta log into CPUA. It's something that's basic. So, if you're not functioning in that 2 years in the game.
Did she know how to?
And I set up these trainings that they're saying, I set up so she could sit with each one of the JAs. So she could know, sometimes you get something better from one person than the other. Plus, they all dealt with different judges. So if you deal with different JAs, they can say, Judge Bridgewater likes this, but Judge Parker likes this, Judge K. Johnson likes it like this, I like it like this. I'm giving you an opportunity to learn it. But if you're not gonna receive it, if you're not gonna be receptive to it, how are you gonna supervise a team when you don't know what it is that they do? How much time, how long does it take for you to get it? But you gotta be willing to get it. You have to be willing to do it. It's not beneath you. How are you gonna tell the staff, I don't get paid to know CPUA? When the judges know CPUA,
Now, should she have learned that in the first year of her tenure?
yeah, Haley answers the phone, she knows CPUA. And you're talking with someone that has a law degree. But if you are sticking your nose up and acting like it's beneath you to copy files when judges copy files, it's beneath you to answer the phones if we're short staffed. You got one person out with COVID, another person had an accident, and why don't you just answer the phone? That's part of anything else to catch all. It's not beneath you to answer the phones. It's not beneath you to copy. It's not beneath you to get the file together. The judges do it. We do it. So why can't you do it? And the reason you can't answer the questions of your staff is because you don't know what they do. Even though I set aside time for you to sit and talk to each one of them, but there's clearly you heard testimony that even though the trainings were set up so that she could learn, she was not receptive. She was just a body sitting there. So I can't spoon feed it to you. I'm giving you training. I'm giving you opportunity to ask them questions. I'm giving you an opportunity, multiple opportunities, multiple chances. And you what? It's beneath you? But you want to be chief of staff. And then you have other departments that are calling us. It was ridiculous. How are you the chief of staff and you don't know how to talk to other departments? You're insulting people in other departments, the sheriff's office, the clerk's office. You're representing the county. And you're being disrespectful and rude and giving less than an excellent customer service? How is that representative of the county? And how can you tell your administrative staff how to give customer service when you are not only giving poor customer service, but belittling them? That's not exemplary of a Clay County employee.
More questions? No. Yes, witness be excused.
Well, she can come sit back down here.
All right. Are there any more witnesses other than rebuttal witnesses?
I have no witnesses at the time, but I would like to tender exhibits 3 through 9, and then 11 and 12.
Ms. Riley, any objections to?
To enter the evidence? No,
Do you plan to have any witnesses or
no,
plan to testify?
no.
Just to confirm for the record, those exhibits are admitted.
Oh, yes, I'm sorry.
Thank you.
Yes, those are the exhibits the county has offered for tender or admitted
Thank you.
over any objections. Closing. You gonna defer?
I am.
Okay, Ms. Riley?
Yes.
Closing argument?
You all have seen and heard the evidence presented today. What has occurred has left my life in turmoil. I'm still unemployed, without unemployment insurance assistance, and I'm forced to move from my home today because I can no longer afford it. So in making your decision, I would like to remind you of a couple of facts. First, the U.S. Department of Labor states that FMLA, when a person returns, after using FMLA leave, an employee must be able to return to their same job or to an equivalent job. An equivalent job means a job that is virtually identical to the employee's original job in terms of pay, benefit, and other employment terms and conditions. An employee should usually be able to return from FMLA to their original schedule and work location. I would like to remind you of a couple of key facts. One, my demotion to office coordinator clearly supports my claim to violation of FMLA rights because it was not the equivalent to the same job function and title I possessed before my leave. Two, Clay County advised the state agency, Department of Labor, that I had poor performance and had performed satisfactorily in the
Objection, this
past.
facts not in evidence. There's been no testimony about that.
I would like to remind you that Madam Chief did testify that I had performed satisfactorily in the past. 3, even if the poor performance claim is true, I was wrongfully terminated because Magistrate Court did not follow Plain County's disciplinary action to correct poor performance, either as Chief of Staff or Office Coordinator. Therefore, I'm requesting that my termination be overturned. And I'm also seeking salary compensation from the date of termination and a salary severance package that extends to the end of 2024. Thank you for your time today.
Ms. Schoenberg, you have 7 minutes and 56 seconds left. But you don't have to use all of it.
I don't always use all of my time.
7:55.
I didn't use all my time this morning. I don't always use all of it.
Can't make any of it.
I wish I could. We had a couple here because it were short
Yeah.
a while ago. The evidence in this case is undisputed that Ms. Riley's performance of her duties was unacceptable by any standard. It is undisputed that she spoke to the staff she was supposed to be supervising and leading in a manner that was unacceptable. She spoke to other departments in a manner that was unacceptable and that resulted in complaints being lodged with the magistrate court. She was insubordinate to the presiding judge, Judge Cates Johnson. She refused to perform duties that she was assigned or to perform them in a timely manner, including critical time-sensitive tasks such as scheduling bond hearings that affected the incarceration of individuals in the Clinton County Jail. Her performance issues had been discussed with her on numerous occasions. She received coaching and verbal counseling. She received a write-up from Judge Wright Hill after the incident of insubordination with Judge Cates Johnson. Excuse me, she had her duties modified. She was still chief of staff. If you look at the notice of termination, Judge Wright Hill is specifically speaking to her duties as chief of staff, and she says that in the notice of termination in multiple places. Regarding the bond hearings, that was a task that was the responsibility of the chief of staff that she didn't handle. The way that she spoke to and managed others as chief of staff was one of her deficiencies. It's clear that that was the position that she held. There was no change in her pay. The duties that she performed were within the scope of the chief of staff, but they were modified in an effort to preserve her employment. All of those efforts were in vain. When the time came to make the decision to terminate, Judge Wright Hill waited after she returned from FMLA to see if anything changed, if anything improved, if anything got any better, and it didn't. So she consulted HR about the decision to terminate, and she followed the guidance that was given by Human Resources. And there was no concern expressed by Human Resources about the decision to terminate at that time. Civil Service Rule 9.206 is very clear about conduct that is unacceptable and that justifies termination. In this case, if you look at the notice of termination that was provided to Ms. Riley and it was discussed with her by Chief Judge Wright Hill on the date it was delivered to her, you will see that the violations alleged include 9.206E, conduct unbecoming, 9.206 J, actions which amount to insubordination, 9.206K, incompetent, negligent, or inefficient performance of the duties of the position held. 9.206R, antagonism towards fellow employees or supervisors, interfering with the proper cooperation of employees or otherwise impairing the efficiency of the operation of county business. All of those violations were identified in the notice of intent, in the conduct that was described, and in the notice of intent that was discussed with Human Resources prior to the decision to terminate. She did meet with Ms. Riley on November 7th, but the termination was not effective until November 10th to allow Ms. Riley the opportunity to submit rebuttal, which she did not do. Excuse me. The only evidence that you have in this case, excuse me, is that Ms. Riley's conduct violated civil service rules, frankly, violated reasonable standards that can be expected of any employee. That she had been coached, counseled, she had been written up. And the fact that her job was in jeopardy had been brought to her attention on more than one occasion and did not produce results. The only evidence that you have, and you've heard it from both judges, they didn't feel like they had a choice. They had gone as far, they had taken it as far as they could go. They had worked with her as much as they could, and they didn't feel like there was anywhere else that they could go. After discussing that with Human Resources, the decision was made to terminate, and we will ask you to uphold it. Thank you.
Madam Chair, I move that we adjourn to executive session to discuss the merits of this case.
Second. All in favor?
Aye.
Aye. Adjourn to retire to executive session. It's 4:08. Oh, yeah.
And we,
Take a break.
bring a motion for a break to the San Francisco.
Where did she go?
You make a motion.
I move that we take a 5-minute break until Ms. Hammond's return.
Second.
All in favor?
Aye.
Aye.
4:15. Well, severe thunderstorm warnings are out.
Resume 4:52 p.m.
All right, Lord, thank you all so much. We made it through another meeting and we got a lot accomplished, at least 3 cases you got taken off the case log. I am happy to stand here and say, and I've never been able to say this before, you all have no cases for next month.
We've never been in that place.
So we've never been in that position.
So,
Never.
you know, I want to say this loud and clearly. Human Resources, we have implemented a lot of different things. One is something that Michelle, the board that we talked about years ago, about implementing mandatory leadership classes for our newly promoted supervisors. So we've done that and we've been going strong with that for about a year and a half. Also, we have a strong focus on employee relations. I refer to the HR team as change agents of the environment. And I really would like to say that we hope that these decreases in cases are the result of some of the things that we're doing and that we will continue to do.
We understand what it is, that we.
Yeah.
we're gonna take it, right?
And we'll claim it. And we will have the rewrite committee. We'll start that tomorrow. Chair Watkins and Vice Chair Smith, they are a part of that. Michelle is a part of that. We have a team assembled that's ready to go. And I know we've tried this a few times. COVID put us to rest the last time, but we definitely will not stop until that project is complete.
Amen.
But your next board meeting is March the 27th. So Michelle, for the first time, there is no deadline.
First time ever,
First time ever?
first time ever, and I've been doing this for a minute, first time ever.
Right.
And I think that's all that I have, board.
Okay.
Am I missing
Okay.
something?
No.
Becky?
Step, Ms. Ambles, maybe it was discussed absent me, but I'm not clear how we are at this point.
Okay.
When,
Yes. Yes, absent the sheriff cases. And then thank you, KT, because that was one thing, I guess that's what Noah was getting ready to say, don't forget the to update on the sheriff cases. It's my understanding that the Board of Commissioners would like to look at these cases at the March 5th board meeting to make determinations. Human Resources, we have provided, working in conjunction with Finance, we've requested itemized pay statements for all of the sheriff appellants. Once HR get those itemized statements, we do pass them along to counsel for the county. And then counsel for the county work with the appellants councils and unrepresented appellants so that they can start the negotiation. But as we speak, the board would like all of that to take place at their March 5th meeting. That has been what's relayed to Human Resources.
okay, let me ask this. And okay, remember, I got that little narrow brain. I have to have things lined up. Are we talking about the cases that were on the January calendar? That was that week that we had, and then the following, just that narrow few cases right there?
No, we're talking about every single case that's on the agenda. That's what we started with. It was our understanding. We provided them, we were focused on those, I believe it was 3-4 days worth of cases. So we went ahead and we provided those. I got further understanding probably about, was it last week, knowing Becky, that the Board of Commissioners, they really want these cases resolved. So my understanding is that at the March 5th meeting is when they will begin looking at these particular cases. Now, keep in mind, Human Resources, we're not part of the negotiation. We have nothing to do with that. Our role is to provide the information and try to make sure that things are flowing as they should. But no, sir, it's not just those. We started out looking at those. I think that was about how many, Becky and Noy, 12, 13 cases. We started looking at those 12, 13 initially, but now we're looking at all of them. Which if you do 13 plus, how much, Becky and Noy?
2 or 4, just giving.
About a total of 32 or so.
I have a question. This one case on the front page, Michael Johnson, it says conflict does not exist. Now, are they gonna include that into the pending resolutions?
The negotiations, Ms. Lancaster, yes, ma'am. Every sheriff case that's on the case log is under review for possible resolution through negotiations.
You know what?
Okay, I say that's a mountain too high to climb.
What were you saying, Casey?
I didn't hear you.
I said, I said, I believe that's a mountain too high to climb. You have to take it one step at a time. And if we're talking about all sheriff's cases, we will not hear a case until sometime midsummer, if we do then, because as I said at the last meeting, it's a monumentous task with the 4 or whatever cases that we gave before. And I say monumentous being for nobody else other than finance. Because that's who's got to figure all these little nooks and crannies from the dollars that are spent and to be compensated if they win or if they settle. So we're talking all of the cases, my God.
I'm gonna give credit to finance, KT, because they're getting those statements back to us quickly. So they're diligently working to be part of the solution. And I'm gonna give kudos right now to Stacy, Lakeisha Feldenhar, and all of those wonderful finance family that we have upstairs. They are working diligently and they have gotten them back to us quickly. I'm actually expecting to have the statements by the end of this week. That's what I believe we committed to. Now, on the other end, with the negotiations, I've been told, that that county has the resources. County will work day and night to make sure that everything is ready. But we're only trying to make sure we control the part of the process that we can.
Absolutely. Thank you.
This has always been the goal of the board, to get our caseload down to where if there was one, it could be heard in a timely.
Yes, ma'am, and y'all have to work very hard for that, and you do have one possible pending. I won't say the department name or anything like that, but you do have one, and I did check with Becky when she went back to the office for lunch to see if the appeal form had been officially filed. So the terminated employee is in the process of submitting his appeal, but he has not done that officially as of lunchtime. So that's why I couldn't put it on there.
When's the
We have to,
deadline?
we have to wait and see if he does, because there are people that reach out and then don't get it done, so.
When's the deadline?
Well, I'm not putting it on record, Ms. Lancaster, so when they have 10, I'm sorry, I misunderstood your question, ma'am. 10 days after the date of the action.
Oh, okay.
Yeah, 10 days after the date of the action.
Next week, I think. Yeah, I think it's next week.
So we've already sent the appeal form to him and all of that, right? We're just waiting for him to, because it just happened Friday. He was terminated officially on Friday. So yes, he would have 10 days after that day, 10 calendar days after that day to file his appeal. And I'm thinking that more than likely he will.
That's Madam Chair, based on that, there's no need for executive session. I move adjourned.
Any other business? No? Okay.
Second.
All in favor?
Aye.
You're adjourned.
All right, I'll see y'all tomorrow.
Yeah.
Thank you.
Good job. You got
All right.
I know. I think I'm gonna be impatient with me.